Sir, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Have a seat, please. All right.
Good morning.
Good morning.
Would you please state your name and spell your first and last name for the record?
Paul Miller, Paulmiller.
Before we get going with your testimony, I want to tell the jury a little bit about your experience and certifications. Do you have a CV that lists all of that information out for them?
I do.
And did you bring us a copy for your testimony
I
today?
did.
Your Honor, may I approach the witness?
Yes, you may.
You're being handed a document. Can you tell the jury what that is?
This would be my CV, curriculum vitae, my list of experience and certification, and a small profile about me.
Your Honor, I would offer Mr. Miller's CV into evidence as the next numbered exhibit.
To be Exhibit 25,
And Your Honor, I have a copy for each one of the jurors. Could we pass those out?
that would be fine.
Thank you, sir.
Permission to publish digitally as well, Your Honor?
Yes, ma'am.
All right. Where do you work?
The Davidson County Sheriff's Office in Nashville, Tennessee.
And what do you currently do for the Davidson County Sheriff's Office?
I'm an instructor within our training academy.
How many years of law enforcement experience do you have?
10 years.
And has all of this been in a correctional setting?
Yes.
Going through your CV and your experience from 2016 to 2019, it says that you were a correctional officer. Can you tell the jury what a correctional officer is?
Sure. So I was an officer that was directly in the units supervising inmates, both as an officer and as a corporal. I would work one-man posts, two-man posts, be responsible for rounds, suicide watch, responses with use of force, dealing directly with the inmate population in a hands-on capacity.
And from 2019 to 2022, you were a correctional supervisor. Can you tell the jury what that means?
Yes, ma'am. So as a frontline supervisor or sergeant, I would supervise officers and corporals that were directly in the units that took on the role that I just explained. And then I moved into a lieutenant responsibility where I was a shift supervisor over an entire building, still supervising officers that were supervising inmates, still in a very hands-on inside the facility capacity.
From 2022 until present day, you are a correctional instructor. Can you tell the jury what a correctional instructor does?
So I was moved over to the training academy after a gentleman wanted to retire and wanted me to take his place. So I teach, my main role is defensive tactics or hand-to-hand fighting. I teach a wide range of things from chemical agents and restraints to use of force theory and policy. I'm a certified CPR instructor, certified first aid instructor, mental health first aid, critical incidents, a wide range of topics that I teach both to incoming correctional officers and in our in-service programs to officers that have been in the job for some time.
In 2017, you were certified as a jail officer by the American Jail Association. Can you tell the jury what that means?
Sure. So the American Jail Association is a nationally recognized program throughout corrections They offer different tests at different levels, officers, supervisors, instructors, administrators, etc., that you can voluntarily seek out. I believe the American Jail Association was 150 question test, and it basically proves your value, your knowledge as a correctional officer. That test, compared to the American Correctional Associations, is very specific into corrections in the jail. And it's something that myself and several other officers that I know throughout my career have done as a form of expression of our commitment and wanting to advance our careers.
Also in 2017, were you certified as a certified corrections officer by the American Correctional Association?
Yes.
I think you kind of just alluded to that, but can you tell us what that means?
Sure. So ACA, or the American Correctional Association, different from the American Jail Association, different administration. Very similar in process, many test questions over the course of a few hours to show your competency, your knowledge, your skill base, and give you that on your resume. But ACA is another accrediting agency that provides standards through correctional agencies across the country. The Davidson County Sheriff's Office is accredited by ACA. Shelby County is as well.
In 2018, you obtained certifications in correctional behavioral health training by the American Correctional Association and crisis intervention training by the Tennessee Department of Correction. Can you tell the jury about that?
Sure. So those were two separate trainings. Behavioral health training, that was a really good introduction from ACA, from the American Correctional Association, into specifically de-escalating and understanding different inmates' mental health issues. There are a wide range of diagnoses that inmates come in with and develop throughout their time incarcerated, and arming correctional officers with the tools to be able to de-escalate those without having to go hands-on has become even more important in the past 2 decades. CIT, or the Crisis Intervention Training, was a different program that was very more focused into specific mental health diagnoses and reality-based scenarios, where we trained and went through a multitude of different scenarios with actors and how we would apply them in a real-life situation, de-escalating people that were having a mental health crisis both in and outside of the jail.
In 2020, you obtained your certification in mental health first aid. Can you tell us about that?
That was a much shorter class offered by a different agency, but mental health first aid is kind of like that Band-Aid when somebody's having a mental health crisis, of still teaching those de-escalation tools, but how can I triage this in the moment right now so that I can get this person safely into a more safe and secure environment, such as a mental health facility, such as just in front of a therapist or a doctor.
And in 2021, you received a certification in 3T Instructor Development course by the Tennessee Corrections Institute and Supervisor Development Institute. Can you tell the jury about that?
So again, those are two separate things. 3T is the Tennessee Corrections Institute, which is the governing body for all correctional facilities throughout the state of Tennessee. They make our policies, they make our laws, they make our minimum standards. They offer a course to certify people that do not work for TCI to be able to teach correctional officers throughout the state. So that is something that if you're going to be an instructor in an academy that doesn't work for Tennessee Corrections Institute, you have to accomplish. Teaching basics, how to teach adult learning theory, and different things like that. Much more focused on the instructional portion of it versus your policy, your procedure, that type of thing. The Supervisor Development Institute is something that the Metro Nashville government does, and that is basic frontline supervisor training, making schedules, writing evaluations, submitting payroll correctly, that type of thing.
In 2022, you were certified in Defensive Options and Strategies by AIRCO. I hope I'm pronouncing that correctly.
You are.
International, and spit restraint device instruction from the Institute for the Prevention of In-Custody Deaths. Can you tell the jury about that?
Absolutely. So, two separate things again. AIRCO International is the company that makes the chemical agent that both my agency and Shelby County use, the 2-ounce can. It's called Freeze Plus P. So that class, done by a man named Rick Gann, who works directly in the training division of Airco International. It is a use of force policy and theory class, very specifically based around the use of their chemical agents and how it is utilized. I had already been directly exposed to chemical agent to become a correctional officer, so I'd been sprayed in the face by somebody who had gone through that class. And then when I went through that class again, I had to get sprayed again by that gentleman in order to be a chemical agent instructor for Airco International. The IPICD, or the Institute for the Prevention of In-Custody Deaths, offers a myriad of classes to try to arm and help correctional officers from making the mistakes in the field of just anything that we've seen throughout our years of people dying in custody. So that one specifically was dealing with spit nets or expectorant shields, the mesh netting that you've seen put on or may have seen put on over somebody's head if somebody is spitting at somebody when they're being taken into custody. So they offer a certification class on safe ways to use it, how to frame your policy to make sure that you're using it correctly, when to leave it on, when to take it off, things like that. So that was another certification that year as well.
In 2023, you received certifications as a tactical weapon instructor, WRAP equipment safety restraint instructor, and
Saber.
law enforcement aerosol projectors. Can you tell the jury about those?
Yeah, so those again are three entirely different things. So our tactical weapon instructor from Armament Systems and Procedures, that acronym stands for ASP. So that class was a very hands-on, reality-based training of use of baton, handcuffs or restraints, and flashlight. It's done by ASP, which is the company. So that was a very hands-on use of force, how to apply force with the baton, correct ways to use their handcuffs, how to use a flashlight in a tactical setting, things like that. The WRAP, the WRAP, made by Safe Restraints, is a product, and we're seeing more and more of it as people move away from the restraint chair. If you don't know what that is, it's not important. But the WRAP is something that basically wraps around, there's like almost a burrito type thing that wraps around somebody's legs, and then there's a vest that goes on over their chest, and you can secure them with handcuffs through it. There's a chain that will tether their shoulder to their legs. It's very effective. There's a lot of agencies across the country that have moved away from restraint chairs into the WRAP because it's a little safer, it looks a little better. So that was another one that my agency, we looked at, we tested it. I went out, had a master instructor come over and teach us how to use it. So that was another very hands-on course that we were certified in that use as well. And then Saber aerosol projectors. Saber is another mass producer, separate from Airco International, of chemical agents. So Davidson County, we use two different styles of chemical agents. We use our small can, the Freeze Plus P, which from my understanding is the same that Shelby County uses. But we also use a large canister that is made by Saber. It's called Cell Buster. It's a little more effective, but it's used in very nuanced applications. So that was simply another type of chemical agent class that we had to go through everything about it, learn about it, how to use it, when not to.
And then finally, in 2023, you were certified as a subject control apprentice instructor by Universal Defensive Tactics. Can you tell the jury about that?
So Universal Martial Arts was a company that was founded by a man named Kevin Johnson, nationally recognized in the field of martial arts and law enforcement, defensive tactics training. He was at my agency for many years. He's worked at ACA. His name is very well known in circles that I would be a part of. Before he retired, he certified me as an apprentice instructor, and that was that training involved, over the course of a few years, a blended curriculum of different martial arts: boxing, Muay Thai, Jiu-Jitsu, Judo, Kali fighting or stick fighting that would translate into baton, weapon retention, all of those different things to prepare me to be able to teach incoming correctional officers the same techniques. And he certified me in the use of that after that kind of blended curriculum with him for many years.
Your Honor, at this time, the state would tender Paul Miller as an expert in the field of use of force.
Any questions questions?
Good question, Charles.
Right. Ladies and gentlemen, just as I allowed 3 medical examiners or witnesses to be qualified as experts in the field of forensic pathology, I'm going to allow this witness to be qualified as an expert in the field of use of force, and he's allowed to give his opinions in that field.
Mr. Miller, did our prosecution team meet with you to gain insight from a correctional perspective and ask you to give your opinions regarding, or here in court regarding this matter?
Yes,
And can you tell the jury whether or not you're being paid for your time and your expertise?
I am.
Are your opinions affected by the fact that you're being compensated in this case?
They are not.
Information that you reviewed, were you able to review the video of this matter?
Yes, ma'am.
Were you able to review the medical examiner and autopsy reports?
Yes, ma'am.
Were you able to review the Shelby County Sheriff's Office major incident packet?
Yes, ma'am.
And the Shelby County Sheriff's Office use of force and chemical agents restraints policy?
Yes.
Your Honor, for the record, that is Exhibit 11.
All right.
Were you able to review TBI interviews with the defendants?
Yes.
Were you able to review PPCT or did you use your PPCT defensive tactics instructor manual?
Yes.
Also, the ACA standards for adult local detention facilities?
Yes.
And did you also consider TCI minimum standards for local adult correctional facilities?
Yes.
Were you able to prepare a report which gives the basis for and explains your opinions in this matter?
Yes, ma'am.
I'm passing something up to you. Can you tell the jury whether or not this is an exact copy of the report that you prepared in this matter?
It appears to be, yes, ma'am.
Your Honor, I would offer that as the next numbered exhibit.
Exhibit 26.
Your Honor, I have copies of the report for the jury.
All
I'm going
right.
to pass those out.
All right.
Mr. Miller, you testified that you have 10 years' experience in a correctional setting, and we've also just qualified you as an expert in the field of use of force. Can you tell the jury whether or not you've ever had to implement some of these policies that you've learned about?
I have, many times.
Can you tell them a little bit about that?
Working inside of the jail for 6 years before I became an instructor, which I've been for a little more than 4 years now. I don't have an exact number, hundreds of times that I have been involved in the use of force with an inmate. I have sprayed inmates. I have wrestled with inmates that were naked, that were covered in their own feces and urine. I have extracted violent, mentally ill individuals out of cells to try to get them to the hospital. I have had to forcefully remove homeless people from the jail that simply didn't want to go back to the streets. So I have been involved both hands-on, frontline, and in a supervisory capacity hundreds of times in different uses of force with inmates.
So is it fair to say, as you give your opinions on these matters, you have been there and done that?
Yes, ma'am.
Okay. We've used the term use of force a couple of times. Can you tell the jury what the term use of force means?
Sure. So a broad term we use to describe an intervention that somebody may have to make into somebody either having a crisis or attacking, trying to harm themselves, trying to harm others, trying to escape, trying to destroy valuable property. There are many reasons that somebody may have to use force, but those interventions are sometimes physical, we use with our hands. They are sometimes chemical, we use things like spray. They are sometimes mechanical, where we use things like holding cells and restraints. Newer age, they are sometimes electrical, where we use things like tasers and shot gloves. So there are a lot of tools and a lot of different methods that officers have to use force against somebody who is not listening, being disruptive, being aggressive, trying to harm people, harm themselves.
What is a use of force policy?
So a use of force policy, a list of guidelines, of definitions, of rules, of things that have been drawn from different court cases and interpretations of both the 8th and the 14th Amendment into ways for people to use reasonable force, proportionate force, when you can use certain techniques, when you can't use certain techniques, what's acceptable, what's not acceptable, what would be reasonable, what would not be, defining things like totality of the circumstances. Most of them are very, very long, lots of pages, because as we get further into implementing new tools and different techniques, things just get kind of added on.
Why are they important?
When you don't have a good policy in place, somebody, number one, coming in off the street, no idea what they're allowed to do, no idea what they're not allowed to do. And, when you think about things like using a proportionate amount of force to the resistance, it's very important. It's one of the things the Supreme Court says we have to do. If somebody doesn't understand what the totality of the circumstances is, the facts and circumstances that an officer knew or reasonably perceived at the time that they elected to use force. I just go in and do something that I learned in jiu-jitsu class, but that's not something that was covered in your policy, that was taught in your training, that's in a lesson plan that you can find somewhere. People make mistakes.
And you've used the term a couple of times, proportionate force. Can you tell the jury what you mean by that?
So using a level of force or a type of response that is not necessarily equal to, it's not what I mean by proportionate, but that is not so far beyond the level of resistance that you're seeing. An example, if I had a young lady who told me that she was not going to go back to her cell and was standing in front of me, not balling her fists, not presenting any type of an immediate threat, not telling me she was going to harm me, and I punched her in the face with all my might, you might not consider that a proportionate level of response. Even though I had a duty to respond in some way to that instance, that was not the correct way to go about it.
If someone is not trained in use of force policies or does not follow their use of force policies, is there a danger?
Absolutely.
Can you
So
tell the jury about that?
3 ways people are taught to defend themselves inside the facilities. You defend yourself physically, you defend yourself legally, defend yourself administratively. So the physical is the actual training with your hands, with your tools, to be able to defend yourself in case someone attacks you or come to the aid of another officer or inmate. Protecting yourself legally, make sure you're understanding what the courts have said that people are allowed to do and not allowed to do. Inmates still have rights, just like you and I do. Some of them are more restricted than others, but that doesn't mean they have a right to unreasonable search and seizure, that I can just do whatever I want to them. And then protecting yourself administratively, making sure that you're following the guidelines that your administration has set forward that they want to see implemented inside of their jails. And when you don't follow your policy, or when you don't have a good understanding of your policy, it becomes impossible to do that.
And could there also be a danger to the inmate?
Absolutely. That's where the number one danger comes from, is inmates will have all kinds of nefarious things done to them, intentionally or not. because you don't understand what you're allowed to do, what your goals are, what your restrictions are, or what your capabilities are on the other end of that.
We heard testimony earlier in this trial that at Shelby County Sheriff's Office, they require all correctional staff to go through a thorough training at the time that they're hired regarding use of force, and then also be retrained on it every single year. Do you think that's a good policy?
Yes.
Can you tell the jury why?
So that initial training to build that baseline understanding, not just of physical techniques, but of just of getting that baseline of what the policy means, what all these different terms are that we mean, how we're going to implement these inside of this theory and policy that's going to be safe for both us and the inmates. Those refresher trainings that happen every year, that in-service type training, things change, rules change. You know, there was a time that every law enforcement agency across the country, and not mentioning names or specific cases, but every law enforcement agency across the country was using a lateral vascular restraint. And now we don't, because things change, right? And that's okay. We adapt to how they work. So as things change throughout the year, as new tools are implemented, as different techniques are learned or honed, or just an opportunity to practice them, that in-service training becomes so valuable.
Now I want to talk about some of the opinions that you have written in your report, and we'll start with items 6 through 8. You dedicated these numbers to talking about the report writing in this case. Can you tell the jury what you have meant by that?
Yeah. If you'll give me a moment to flip to it.
Yeah.
So 6 through 8, reviewing the written and incident reports, I was able to review the major incident package. There was only one actual incident report from somebody that was involved in the entire altercation from the 4th or the 5th floor, and that was an Officer Howell. I did not find any written incident reports from either Officer Jones or Officer Parham. So multiple different violations here that I had found. If you start with 6A, Shelby County Sheriff's Office policy, all instances involving any use of force, remaining in restraints at the end of a shift, discharging firearms, use of less lethal devices, which chemical agent or pepper spray would qualify as a less lethal agent, will be documented, use of force to control inmates or any other weapon will be documented in writing and in detail as soon as possible by each individual employee involved in the use of force and by each employee witnessing the situation. Written reports must be completed before the end of the shift or workday. So in looking for reports are so valuable because they can give insight into what the officer was feeling in that moment, why justifying their actions that they
And
took.
we're not talking about these two.
Sure.
We're talking about other parts that would have been other people who would have made reports.
Sure, I kind of just mean in general,
Okay,
right? Like
thank you.
writing incident reports in general at the outset of an altercation. You have different things you remember, you have nuanced emotions, you have how you were feeling, and as time goes on, those things fade, and it becomes more and more challenging to be able to actually get a good description or picture of what was happening. So when you don't have incident reports for an incident, all you have to go on is the video.
And talking about the video, did you have an opportunity to review that video?
Yes.
And you've broken your report up into 4th floor and 5th floor, so we'll do that also here.
Okay.
First, let's talk about the 4th floor. You said that one of the materials that you considered in rendering your opinions in this matter was the Shelby County use of force policy. And Your Honor, we'll be referring to excerpts from exhibit number 11 for the next few slides.
All right.
Mr. Miller, I'd like to talk about some of the use of force provisions that may apply to what happened on the 4th floor, to keep in mind during your testimony later on when we go through the video
Sure.
about the 4th floor. First one I want to talk about is 80607E, which says prior to any use of force, non-force alternatives, such as verbally resolving situations, must be attempted to the extent that time and circumstances reasonably permit. Can you tell the jury why this particular part of the use of force policy may apply to what happened on the fourth floor?
Yeah. So essentially all this is saying is that before you put your hands on somebody, you talk to them first. And we try to figure out, this is very common across the entire country in law enforcement and corrections. We try to verbally resolve situations, gain that voluntary compliance with our mouths. And before we're going to actually unintentionally or intentionally hurt somebody, issue chemical agent, have a use of force, we try to verbally resolve it. So there was a camera inside of Mr. Freeman's cell, and whether or not his behavior leading up to the officers walking up to serve him lunch was negative or poor, he's in his cell, the door is locked, he doesn't appear to be attempting to hang himself or bash his head on the wall, which are unfortunately common ways inmates try to commit suicide in jail or try to harm themselves. I didn't see any of that on the video. So when you see somebody, you have a camera, you have the ability to look through their cell window and witness behavior that you deem unacceptable. You have that time and opportunity, it appeared at that moment, to gather a team, have somebody else talk to them, have medical talk to them, a lot of different options.
Next one I want to talk about is 80605N and 80609A, B, and F. You said get together a team, so they have a definition in the use of force policy that is defined: planned use of force, a plan of action in situations where time and circumstances allow for consultation with and approval by the shift captain or above. Is that what you were talking about when you were saying you have time to gather a team if you can see that the inmate is undergoing some type of distress?
Yes. So secured behind a door, as I said, does not appear to be an immediate threat to himself. Secured behind the door, there's almost no way he could be an immediate threat to anybody else. He's in that cell by himself. You have access to the camera to be able to look in the cell from a distance. You have access to look through the door and witness that behavior. And this is exactly what why this policy exists for that type of a situation. So I can look in, witness behavior that I deem to be negative, inappropriate, aggressive, what have you. I get other people involved. I believe we're going to talk about CIT here in a moment. So we get people that may have a better rapport or may have a better relationship with Mr. Freeman, may have some more mental health training that I don't have. Maybe just get along with him better, and not just him. This could be anybody inside the cell. So when I have that time and opportunity, I can call for other people to come and try to talk to him so that we don't have to put our hands on him. I can call for medical and mental health staff so they can come and talk to him so we don't have to put our hands on him. Eventually I'll call my supervisor, as this definition tells you to do. And if we have to get through all those different levels now, because this person is secure and safe and not going anywhere, we get through all those different levels of people trying to talk to him and we're still not there. That's where a supervisor, as the policy defines, might initiate a planned use of force, where we'll get out a handheld camera, we'll get other types of chemical agent, we'll get multiple people in there, because the more people I can send in there, the less hard anybody has to fight, if it came to that, which is going to lead to less injury for everybody involved.
And going on about planned use of force in 80609A and B, it says any planned use of force will be carried out under the direction of supervisory or higher level staff, and only after consultation with and the approval of the shift captain or higher ranking authority. And in time and circumstances permitting, the chief jailer or chief of security must be contacted for authorization of planned uses of force involving batons, chemical agents, excluding aerosol sprays. And then going on to F, for every planned use of force, a medical staff employee may be available in the area of the incident prior to the actual use of force, unless, and then it has some exceptions to that. fourth floor video, was there anything that led you to believe that somebody had planned to use force before going to Mr. Freeman's cell?
Yes.
Can you tell the jury about that?
I've reviewed the video dozens and dozens of times, and it appears that the first officer that walks into the unit, there are 3 officers there. So Shelby County's jail is built like an older jail. The officer that's at the end of the hallway is likely operating the locking mechanism on the sliders, and that's how the sliders are opening. It's not like an electronic, So there are 2 officers that walk in. One of them is holding styrofoam trays. That's the food, right? And then the first officer that walks in, he appears to have his chemical agent in his right hand, which when you've got multiple people that are going to serve lunch to people, right? This is likely a one-man post. Most posts are in jails nowadays. So when you've got multiple people there already, that tells me that something might be up, just in my experience. And then when I've already got my spray out and I've got it preloaded, I have a holster for it. We're supposed to. But I have my spray out, that tells me that you were likely preparing to use it.
And did you see anything in the materials that you received that there was any authorization for or any supervisor approval for this planned use of force for deploying the chemical agent?
No. And as I said, the only actual incident report that I saw from this incident came from an Officer Howell. And truth be told, I don't know who Officer Howell is.
All right. Now I want to ask you a couple questions about, I've got one other one I want to talk about, and that's 806.10F, which says, in situations where physical force must be used, employees are specifically prohibited from punching or kicking an inmate into submission unless there are no reasonable alternatives. Can you tell the jury whether or not this section of the use of force policy would apply to what happened on the fourth floor?
It absolutely would. There comes multiple times where inmate Freeman is on the floor in what I would deem is a very reasonable place to flatten him out, get his hands behind his back, get restraints involved, and we continue to throw strikes. The word kick here, stay with me for a moment, there's not a single kick in this entire video. What there are stomps. So kicking is something that is defined, and it's something that we teach in law enforcement and just martial arts in general. A front kick, where I might try to create myself some distance and be able to step back and get to my radio or a weapon. A round kick, where I might throw my rear leg and try to hit somebody on the outside of the thigh where like that sciatic nerve is. It's very painful, it's kind of stunning, right? But what we have in this video are stomps, right? And stomps are something that are not taught in any corrections-based, law enforcement-based defensive tactics program anywhere. So those are so beyond the level of this policy that they're not even addressed, right? So there are multiple times, we use the word kick to just define our foot hitting something. But there is in martial arts and defensive tactics training, there's a big difference between a kick and a stomp.
And then I want to talk about another one, 806.14A and H, which says all personnel authorized to use chemical agents must be trained in its use, and the treatment of individuals who are exposed to chemical agent, and the amount, and then H says, the amount of and type of chemical agent used and the means of dispersal will be limited to that which is necessary to achieve the correctional objective. Can you tell the jury whether or not this applies to what happened on the fourth floor?
It does. So when we get into the treatment of chemical agent, the 3 main things are water, air, and time. So getting somebody away from an exposed area, getting either medical or sometimes it's correctional staff themselves to wash somebody's face with water, and then just talking them through the process. It's part of the reason that we spray correctional officers when they come through a correctional academy. partly so you understand what it feels like when inevitably you're going to catch some overspray in an altercation, which I've caught many times. Somebody goes to spray an inmate, they miss, we're all humans, it happens. Or you're just involved in an incident where there may have been too much utilized and you feel it in the air, it hits your face, it burns. But also so we can help inmates through it, so we know what it feels like and you can tell them exactly what to do, how to breathe, how to wipe your eyes, different things like that. Our means of dispersal will be limited to that necessary to achieve the correctional objective. A longer way of saying that you use as much as you need to, right? We don't want to spray and spray and spray and empty 3 cans on somebody that is listening now, or on the flip side of that, that it's not working on anymore. You know, we don't, spray is not a magic wand. It's not something, the policy understands it, the instructors understand it. It's not something that you spray and then just stand there and wait for the person to comply. People have very different reactions to chemical agent. So we spray, we engage, we use that advantage that we get in the moment from it, and then we move on to something else if it's not working.
Now I want to talk about the pod where Mr. Freeman was assigned for Juliet, or as we refer to it here as 4J, which is a suicide prevention and mental health observation unit.
Okay.
Is having people who are suffering mental health issues being in custody something that happens a lot?
Yes.
Can you tell the jury about that?
You know, over the past 30 or 40 years, mental health institutions and treatment facilities across the country have closed. Lack of funding, lack of commitment to them, whatever the reason is, that's not the important part. But we still had people that had severe mental health issues. We have started to drop the stigma around mental health issues, and they're being reported in greater numbers now. Not to say that we have more of them versus the 50s, but people are not scared to talk about it anymore. So what you have is a larger population of people with diagnosable mental health issues that occasionally go out and do nefarious things, whether they remembered them or understood them or not. And without the mental health facilities, they still needed somewhere to go, that they were going to be safe, but that also everybody else would be safe for them. And across the country, anybody can tell you they've wound up inside the jails. So that's why you've seen such a big push in the past 15 to 20 years of mental health and de-escalation training for correctional officers, because that's the clientele that we're getting now.
So dovetailing into my next question, you kind of, in a correctional setting, you almost expect to have people who may be suffering from a mental health issue.
100%.
We heard testimony from the chief inspector of the Shelby County jail that correctional officers are trained how to properly engage with those who have mental health issues and suicidal ideation. Is that a good policy?
Yes.
And why is that training important?
It's something that unfortunately, inevitably is going to happen. The numbers of the last time the Federal Bureau of Prisons did a study inside of their own prisons, it was upwards of 80% of males that were diagnosable mental illnesses, and I believe the females were higher, even though they have much smaller population overall numbers. So it is inevitable that you are going to come across somebody, regardless of where you are in that jail, that has a diagnosable serious mental health issue that you will, if you have never encountered it or you've never even read about it, you will find it very difficult, if not impossible, to communicate with them in a way that they can understand.
We've also heard testimony from the chief inspector that this particular unit is different than other units because it has video where the person can be observed, but also because there's only one inmate per cell. Can you tell the jury why it's a good idea to have one inmate per cell if somebody is either suffering from suicidal ideation or from a mental health issue?
Sure. So that honestly can go two directions. Somebody that's suicidal, acutely suicidal, like I actually want to die today, I have a plan, I'm going to do it. Absolutely have to segregate that person from other people. You don't want to give somebody else the opportunity I want to hurt myself, I'm in a cell with you, and I sit there and poke at you long enough until you hurt me, because that's what I wanted to happen. You don't want that to happen. You take all the property away from the person. On the flip side of that, there are people that might get triggered by that type of situation where it might actually make it worse. Being in long-term segregation is not something almost anybody does anymore, because it's very, very it's very hard on the person psychologically. But separating people, not having them, you know, housed with other people when you're acutely suicidal, that's very common and standard across the industry.
Just because they're in one cell, a one person per cell, a one-man cell, does that necessarily mean that they're more violent than other people?
No, I wouldn't say so.
So you've already talked a little bit about there being bars on the cell that makes it possible to view what's going on inside the cell if you're standing in front of it and the video. If a person is obviously suffering a mental health concern, what is the best practice for dealing with that person?
We talking like the door is still closed?
Yes.
Yeah, so I talk to them, depending on my level of rapport, relationship, understanding. Talk to them, find out what's wrong, find out what I could do within the confines of my job and policy to try to rectify or help the situation, or just help the person. Sometimes all people need is someone to listen to them for a moment, right? So I would talk to them, and if I weren't getting anywhere, I might grab one of my friends, one of my coworkers, the medical staff, my supervisor, and kind of just go through that entire planned use of force process. Not even necessarily planning for a use of force, but I'm still going to move up my chain as I go through. Okay, I didn't get this done, it's your turn, right? You didn't get this done, I didn't get this done, now it's somebody else's turn. We just kind of set that pride and ego aside, and let's work on this as a team, rather than, okay, I couldn't do it, let me open the door and have at it.
Now the doors to the cells in 4J appear to have food portals. Can you tell the jury what that is and why?
Sure.
the
So
doors-
the doors of this jail appear to be older style, so we don't build jails like that anymore. Those are what you'd call a slider, so there's wheels at the top and they move horizontally. Most jails nowadays build them like detention grade, real thick steel doors on hinges, normal doors that you would see. But a food portal is essentially a separate cutout into a door that has its own locking mechanism, that it might be the same key as the cell door, it might not be, sometimes they're different. But I can open the food portal, and just like it says, I can pass the inmate meals, I can pass the inmate paperwork, commissary, mail, books, information. You can have conversations. It's where we restrain unruly individuals or individuals that we need restrained. Essentially, it's a way to do a lot of things without having to open the door and both expose myself or the inmate to harm.
So if a person is suffering a mental health concern and a food portal is available and it's time to deliver food, what is the best practice for what should be done?
You pass it through the food portal. That's pretty well its number one job. Colloquially, we call them pie flaps. And that's the exact reason, because you get used to passing pie through it.
You've already touched on this in your prior testimony. You talked about the correctional officer who's approaching Mr. Freeman's cell with his chemical agent already out of the holster and in his right hand.
Mm-hmm.
Does that cause you any concern?
Yes. If you're walking into an otherwise benign situation with your chemical agent already out, it tells me that you know there's a problem and you're expecting to have to respond to it. And how Shelby County's policy is laid out, it seems like they should have called for supervision before they responded to it, just the two of them.
If the correctional officer had used the food portal or the pie flap, as you say, do you have an opinion regarding whether or not the incident which follows could have been avoided?
I absolutely think it could have been avoided.
Tell us about that.
You open the pie flap, you set the tray on the floor. I'm sorry, you open the food portal, you set the tray on the food portal. If Mr. Freeman takes it, excellent. You close the food portal, lock it up, you go about your day. If he doesn't accept it, I might set it inside. I might take it back and give him a moment. We still have a constitutional need to feed inmates. Just because you're being unruly doesn't mean you don't get to eat. The Supreme Court says we're going to feed you. So eventually, if I'm having a hard time getting food to this person and they're not in the midst of throwing.
Yes. Rather than y'all look at, we're gonna take a short break, okay? You need to work down your breakfast anyway, so we'll be back with you in just a few minutes.
entering the courtroom.
All right, Ms. Henry, may continue.
You may be seated.
Thank you, Your Honor. Mr. Miller, I'm showing you what's already been entered into evidence as exhibit number 12. At this time, let's walk through the video and some of the things that you've been describing to us. Can you point that out on the video? And I'll have some extra questions for you about it as well.
Sure.
So for the record, we're starting playing at the beginning of the video.
So, my first question is, why were we not using the pie flaps or the food portals to hand them food? Why did we decide to open each of these doors and potentially expose ourselves to altercation? I've already mentioned it, but why did we already have our chemical agent out in our hand?
I'm pausing here at 37 seconds in. Where is Mr. Freeman at this point?
He's on the floor, appears to be face down. You can see his buttocks, and you've got several officers striking and stomping on him. And this is one of those first opportunities to move into different techniques rather than striking.
What is a controlling technique?
So controlling and clinching techniques are, rather than striking, getting control of limbs, getting control of the hips, getting control of the shoulders with your arms, with your body weight, folding the legs up, flattening the hips out, gathering up the arms and putting them behind the back, different things like that. And I don't see any of that happening here.
Should that be happening here?
Yes.
Why?
There's a reason that law enforcement agencies across the country have moved away from striking-based curriculums into grappling-based curriculums because they work better, they look better, they're more effective, and they're safer. Simply striking somebody to gain compliance from them is typically not effective. But when you can grab a hold of them and move them into the position and help them gain that voluntary compliance, you get a lot better results. And that's part of the reason Shelby County's policy says they prohibit people from striking them into submission.
When somebody comes out of their cell in the way that Mr. Freeman did, what is the objective?
Try to get the person on the floor, handcuffed, and either placed back in their cell or put into a holding cell, maybe a medical evaluation, but realistically in a safe room like this, we would call them, like a suicide watch room, a mental health ward. This is probably the last place they would go anyway. So if they went to a holding cell, it would likely be for a medical evaluation, and then they would more than likely go back to this cell.
We need to get him in control for his safety.
The first thing is typically you get them on the floor and get them restrained. Handcuffs, leg irons if they're available.
We know that chemical agent is about to be sprayed, and you've testified that you have a lot of experience in chemical agent.
I do.
Can you tell us a little bit about chemical agent?
Sure. So the small 2-ounce can, Freeze Plus P, same product that Davidson County uses. It's a 2% main ingredient blend, 1% OC. This is the oleoresin capsicum. That's the active ingredient in the capsicum pepper plant, or the pepper spray portion of it. It's hot. It's classified as an inflammatory, so like it makes your mucous membranes and your nostrils, a lot of snot, a lot of drooling, right, or spitting. Inflames your eyeballs, your eyes involuntarily slam shut. It also has a secondary ingredient called CS, or orthochlorobenzylmalononitrile. That is
That'll
the
be fun for the court reporter.
yeah, I can try to spell it if that'll help.
That's
So,
okay.
that is the other 1% active ingredient in Freeze Plus P. That is the solid, it is the crystals, it is the lacrimating irritant portion of it, which essentially means that it irritates the skin. Those crystals stick into the skin, causes that like involuntarily slamming shut of your eyes, and they act in conjunction with each other. Not all chemical agents use both of those ingredients. Freeze Plus P uses both. Saber Red, for example, completely different product, is only an OC formulation, the oleoresin capsicum.
So you just said how most people would react if chemical agent is sprayed on you. Does everybody react in the way that you just described?
Most definitely not. So, chemical agent, I had a young lady I went to the academy with. She took direct exposure to the face, did her 10 push-ups, said my agency's mission statement, wiped her face off, and she was fine. She got to watch the rest of us cry and scream for 30 minutes. People that like really spicy food, people that have been exposed to it multiple times throughout their life, may not react as harshly as someone who hasn't, right? I react pretty harshly to it. I've got plenty of friends that, or people that I have seen that don't.
When it gets sprayed on a person and it's on their skin, what does that cause the skin to be like?
Sure. So OC or CS, it inflames the skin. It stimulates your vanilloid receptors, which icy hot is the same type of compound where it makes it feel like your skin is on fire, even though it's not actually on fire. So the skin feels hot, red, and inflamed. Your eyes kind of involuntarily slam shut. You have that like psychological inward focus on pain. You're coughing, you're wheezing, you're gagging. Sometimes you're spitting. There's snot pouring out of your nose. It's not a pretty sight.
Can it make your skin oily?
So, oily. The
Slick?
oleoresin capsicum is the oily extract of the capsicum pepper plant. The main ingredient in all pepper spray is water. The carriers are water. And the reason for that is because 30 years ago, when we used to dissolve all of those oil-based resins into oils to use to spray on people, it worked fine, it stuck to people, but then we invented tasers and we started lighting people on fire. So to use a non-inflammatory substance and carrier, your propellant and your carrier have to be water-based, right? So it is slick, just like any water type might be, because there's a little bit of that oily resin. It's a very small percentage of the overall formulation. A person is slippery, especially once the skin feels hot. You're now doing cardiovascular activity, you start sweating and perspiring, and you've got those fluids mixing together.
Is this the reason why people who are using a chemical agent must be trained in being exposed to that chemical agent?
Among others, yes.
And is it possible, even though it gets on one's skin and can make the skin a little bit slick, is it possible to get somebody under control once they've been sprayed with chemical agent?
I have done so many times in my life.
Even a naked person?
Unfortunately, many naked people.
Okay. All right, we're gonna go ahead and play on for here, starting at 37 seconds.
So that large silver can, that is a different brand of chemical agent that Shelby County employs. I'm not even sure if it's in evidence or not. But it's not designed to be a blunt object. It's designed to spray chemical agent. So when we're talking about a situation where we're using an unsanctioned blunt obligation for that, and I don't see this incident rise to that level.
Since Mr. Freeman has been on the ground, and for the record, we're at 52 seconds in, have you seen him strike at anybody while he's on the ground?
No?
Have you seen him use force against anybody since he's been on the ground?
Not since he's been on the ground. You know, he comes out of the cell. They couple of strikes, whatever it is, get him down. But now he just looks like he's moving and wading his way through a sea of people.
And what are those people doing?
They appear to be punching and stomping.
And as you read the use of force policy in Shelby County, is that in compliance with that use of force policy?
It is not.
At any time, and I'm kind of skipping ahead and we'll watch through the whole video, but did you ever see Mr. Freeman have any type of weapon on him or anything like that?
I did not.
And did you ever, how many people are Mr. Freeman?
I'm sorry?
How many people is Mr. Freeman?
Just one.
Okay, and how many people are stomping, punching, and using objects to strike him?
Several.
We're starting again at 52 seconds. Pause here.
Yeah,
At a minute and 15 seconds, what is it here is happening with Mr. Freeman as he's on the ground?
This officer that's on the right, that's kind of behind this officer in the foreground here, this was the first time during this incident that I was very happy with somebody's actions. This person appears to be grabbing hold of Mr. Freeman's feet, trying to flatten them out. Maybe he's trying to fold them up so we can hold him still and get leg irons on him and then get him into recovery and get him out of there, right? And I'll never be able to understand why this person was moved out of the way by this officer in the foreground. But that's what I saw here, is it appeared somebody tried to hold him to the ground so that somebody else could get restraints on him.
And that is one of those controlling and clinching techniques that you said.
Absolutely.
And
That's when
when they tried to do that, what happened?
this foreground officer moves them out of the way, and then Mr. Freeman gets up and continues on.
We'll start again at 1 minute and 15 seconds.
So, why is everybody backing up?
Tell me why that has a concern for you.
Your problem's over here. Why are you going the other way? We correctional officers are paid for what they might have to do, which you might have to respond to. And running away is a poor response at best. There are several officers throughout what we just watched that appear to be being forcefully removed from the situation. I could be incapacitation, like they were oversprayed and couldn't see anything. It could have been emotional. So without incident reports, it's very difficult to know what state of mind those people were in at that time. But just as you get throughout this hallway, people continually move the other direction rather than move into control and restrain and keep them down or pin them up against a wall or apply leg irons or just any of those other things that we teach people to do on an almost daily basis. And it's difficult for me to understand why.
If the controlling techniques that you've described had been employed, and if sheriff's deputies and officers had employed those even after he comes out of that pod, would he have ever even gotten to the fifth floor?
I don't think so.
Let's start again at 2 minutes and 12 seconds. Okay, now we see Mr. Freeman holding on to somebody's leg
Yep.
and him being pushed away. Holding on to the leg, describe to us your take on that part of the situation.
There's a big difference between a person grabbing your legs trying to take you down and someone holding on to you. A naked man holding on to a leg like that, he's giving you the opportunity to restrain him, to control him, and you step away. You know what we just witnessed, where the gentleman in the lighter shirt initiates a throw, right? And I say throw very specifically because that wasn't a takedown. There was no connection with it. He didn't go with him, right? It was a throw. But then he doesn't follow up. So he's now done all this work to put Mr. Freeman in a position that he could go and gain actual control over him, and then lets him back up.
And after Mr. Freeman is on the ground, after he's thrown to the ground, do you see people around who could have used a control and clinching technique?
Yes.
Instead, what do?
They back away. Several of them continue to spray, and just nobody physically engages.
Start again at 2 minutes and 32 seconds. Mr. Freeman is laying on the ground. People are around him. Do you see anybody trying to take control of him?
No.
Now we see him holding on to somebody's leg. Can you give us your take on this?
Once again, he's giving you an opportunity to gain control. You know where his hands are. You know what's in his hands. He's giving you the chance to drop to a knee, staple one of those forearms to the floor, gather up the other hand, put a restraint on it, put the other hand behind his back, and you don't take it.
And for the record, we had paused at 3 minutes and 1 second. We're starting again at that moment. Mr. Freeman gets up. Is there anybody there to take control of him?
No.
Well, there's people there, but does anybody do it?
No.
Do people appear to be going away from where Mr. Freeman is?
Yes.
Does that make sense to you?
No.
Mr. Freeman is on the ground and a lot of people are around. Was there an opportunity to get control of him?
There were several.
Did anybody take it?
No. At this point, I also don't understand why every door on this floor appears to be open. We're leading out into a central stairwell escalator area. And, moving into the 5th floor, obviously that door had to be open to get onto the 5th floor too. So these egress routes or these emergency routes for people to be able to respond to codes, as they let Mr. Freeman continue to get up, allowed him to move throughout the facility freely. Doesn't make sense to me.
Did you ever see Mr. Freeman with any chemical agent in his hand or spray anybody with it?
I've watched this video, like I said, several dozen times, and no, I've never witnessed it.
Starting again at 4 minutes and 51 seconds. correctional officers are around, has anybody tried to get control of Mr. Freeman?
No. And this 15 seconds from the bottom of the escalator to the top, I understand that, because I wouldn't necessarily find it safe to fight somebody in the middle of a moving escalator either. So if we let him get on, I would probably let him get all the way to the top and then engage. But
At
we
this
shouldn't have let
point,
him get on.
How many people are on the escalator?
It appears just him. Several people went down a different one, but
Anything from that moment? We're gonna pause here at 5 minutes and 28 seconds. Now, he has gotten to the 5th floor, and I want to stop and ask you some questions about the 5th floor.
okay.
Just a second. Okay. Before we move on to the 5th floor, do you have an opinion as to the actions on the 4th floor, as to whether or not the actions of the deputies was objectively reasonable from a totality of the circumstances perspective?
I do not find their actions objectively reasonable.
Well, he answered, I do not.
Well, may we approach on that?
Yes.
The defense is going to call their own expert, and I just wanted to say, part of the reason we were so. Part of the reason why I'm spending time on the 4th floor is their expert spends at least 5 pages of his report talking about the 4th floor, and we're not gonna call him again after that. Their report.
Mr. Miller, do you have an opinion as to the actions on the 4th floor, as to whether or not the actions of the deputies was objectively reasonable from a totality of the circumstances? Do you have an opinion about that?
Yes,
And what is that opinion?
that they were not objectively reasonable.
little bit about the fifth floor, and just like we did with the fourth floor, we're gonna go to the use of force policies that may come up or be at issue when we look at fifth floor video. First, I want to talk about use of force policy 80607 F and G. F, the type and amount of force used must be reasonable given the situation and the correctional objective to be achieved as defined herein. And then also the level of force must be limited to the amount of force necessary to control the situation and achieve the correctional objectives as defined herein. Will this come up as we look at fifth floor video?
Yes.
Can you tell the jury how?
So the amount of force used must be reasonable given the situation and the correctional objective to be achieved. That means whatever we're doing by using force, we have to have a legitimate penological reason for doing so, like gaining control of somebody, like securing somebody in a holding cell, like securing them in restraints, and that our response must be proportionate. Right? We're not going to go above and beyond when we don't need to anymore. On the flip side of that, we're not going to go so far below that it puts our deputies in danger of getting hurt themselves.
80607H says the use of force must be terminated as soon as the justification for its use is no longer present. For example, when an inmate has stopped resisting and is under staff control. However, force may be reapplied if the resistance begins again and the conditions for the use of force are present again. How does that come up on fifth floor video?
Sure. So once somebody is secure, once somebody is no longer an imminent threat, we don't need to continue using force against them. It's just a fancy way of saying that. However, things can change rapidly. They're tense, uncertain, they evolve very quickly. So we need to be prepared and have the tools for, I've restrained somebody, I have control, they're no longer resisting. They may do so again. So one of the most important things a correctional officer has to learn is that you have to be able to ramp up your response, but even more importantly, you have to be able to ramp it back down when the situation calls for it.
Why is it more important? Why do you view that as a more important to ramp down?
My experience, human beings find it easier to get angry than they do to get calm. It is easier to go into that fight or flight state than it is to come back down from it. But that's what we pay correctional officers to do, myself included.
80607N, inmates may not be placed face down in a prone position while in restraints because of the possibility they may be unable to breathe properly and asphyxiate, deprive a person of oxygen, usually leading to unconsciousness or death. If an inmate must be placed face down in a prone position, he or she must be observed continuously by security staff. Employees must exercise great caution when placing their body weight on an inmate in the face down position and must ensure the inmate is able to breathe effectively. Once the staff has gained control of the inmate is compliant, the position must be changed as soon as possible. Can you tell the jury how this comes up in fifth floor video?
So this is the first time the policy mentions asphyxiating, or law enforcement, we simply refer to it as the position that the body gets put in makes it difficult for a person to breathe. And I know there's a medical definition of it, and that's fine. So we typically wind up with inmates on the floor in an altercation. That's the safest place for us to put them to be able to effect putting restraints on them, and most of the time it's in the prone position. But we have found through years and years of law enforcement experience that if you keep somebody in that position for a long time, particularly putting pressure on them, that it makes it difficult, if not impossible, for them to breathe. So Shelby County found it important enough to prohibit and talk about the risk of asphyxia when you put somebody prone and restrain them and put weight on their upper respiratory organs, not once but twice in their policy, which tells me that at least somebody thought it was very important.
Okay, and 80607P, medical attention attention must be provided to those injured and those possibly injured as soon as possible following any use of force. The captain or designee must document medical assessment of all inmates upon whom force was used and all those using force. How does this come up in the fifth floor video?
It appears several minutes in, after inmate Freeman is restrained both with leg irons and handcuffs, that he needed medical attention, and it doesn't appear that any correctional officers offer it to him. Every correctional officer, per the Tennessee Corrections Institute in the state, has to be certified in both CPR and first aid. That's a minimum requirement for detention facilities. So every one of those correctional officers would have been certified in CPR and first aid.
And 806.10G, employees are trained to use physical force such as control techniques, compliance holds, and/or chemical agents to achieve inmate compliance. In situations where physical force must be used, employees are to exercise extreme caution when placing their body weight on an inmate, especially when holding them in a prone position, lying face down. Officers must be aware of the possibility that the inmate may be unable to breathe properly, which may cause asphyxiation. Any comment about that?
Someone felt it was important enough for the officers to understand it that they put it in a policy twice, which is uncommon at best.
Twice and trained every single year.
Yes.
Now we're going up to the fifth floor, and we'll go straight to video here and walk through your opinions. Is that okay?
Yes, ma'am.
Okay. And also, just a note, this particular video that has been offered into evidence, is that the exact video that you looked at before? Is it cut exactly the same?
Yeah, outside of the names across the top.
The time signatures are the times on here when we're saying 5 minutes and 28 seconds in.
I believe so.
It's a little skewed.
Yeah,
Would you agree with that?
I haven't been paying super close attention to the timestamps.
All right. We're gonna start again at 5 minutes and 28 seconds. Pausing there. At 5 minutes and 34 seconds, what has happened with Mr. Freeman?
So he's placed on the floor via a takedown or a couple of strikes or whatever the case may be, but he's now appears to be on the floor or on his way to the floor.
And Stevon Jones, who has a yellow circle around his head, what is he doing?
He appears to be stomping on Mr. Freeman's legs.
Can you tell the jury whether or not that is in compliance with the use of force policy?
It is not.
Okay, and why would that not be in compliance with the use of force policy?
Again, prohibits, their own policy prohibits strikes and kicks to move an inmate into submission, and it's also just not super effective. If you were to move down and control the legs with your body or your arms, you'd see a lot more success.
And we'll start again from this moment. I'm pausing at 5:56.
It does appear slightly off from my report.
Right.
Initially restrained with handcuffs at the 5:53 mark, and they're still being put on, so.
And Judge, I don't want to interrupt. If it helps, Exhibit 20 is the video with the proper timestamps. I don't know if that helps you or not.
Thank you. I'd rather play through this one.
Yeah.
If we could just describe it, just with a note to the jury that the times are a little bit off on the report. Okay, at this point, at 5 minutes and 57 seconds, have we been able to see a handcuff?
Yeah, I believe it's on his left arm as it got moved behind him, or his left wrist.
So we have the first handcuff, and starting to play again at this moment. And pausing at 6 minutes and 22 seconds, has the second handcuff now been applied?
I believe it's on, yes.
Okay. And if the objective of the use of force was to get Mr. Freeman in control, has that objective been accomplished?
Somebody's prone, naked, handcuffed behind the back. There are very few humans on the planet that continue to be scary when they're in that position.
So what do you mean by that?
I would say yes, your objective has been completed. Would you love to see leg irons if and when they're available? Yes. However, I doubt there's a person in this courtroom that can move from a prone position with their hands strapped behind their back and stand up all the way without the use of their arms. It's very difficult.
So after he has handcuffs on him, what is the best practice to do at this moment, especially since he's in the prone position?
Sure. Via their policy and just via the industry standards and guidelines, we move people into the recovery position.
What is
which
that?
is essentially we pull them up onto their shoulder. We get the weight off of their lungs and off of their chest. It's easier to watch for breath sounds, apply a sternum rub if you had to, have conversation with the person, and just overall monitor their vital signs and health better. If they continue to not be an issue and they're just recovering, catching their breath, you move them into a seated position, eventually into a standing position, into a secure location, holding cell, get them seen by medical as quickly as possible. Even in the event, via their own policy and my experience, I move somebody in their recovery position and they continue to be disruptive. We'll just say active aggression. There are many techniques. You underhook that top arm. You place a knee in the elbow pit of the person while they're on the floor, and you can really hold them in a good, secure location while keeping their weight off of their chest on their shoulder, and they're not going to go anywhere because you're putting a little bit of pain compliance into their wrist via the handcuffs. But if it got to a point that they were so disruptive you couldn't control them anymore, you place them back prone, right? Maybe now we apply leg irons on. I could put my elbow or I could put my knee somewhere in the butt, somewhere in the hamstring, somewhere even in the lower back, on the arms, on the shoulders. A lot of things that don't involve placing weight across the back, and I can keep this person pinned here until they decide, okay, I'm through, right? Or I have that compliance, and then we start the process all over. So it's that constant monitoring behavior and being able to ebb and flow along with it.
We're starting again at 6 minutes and 22 seconds. Do you see Mr. Freeman actively resisting at this point?
No.
Is there any reason that you can see why he wouldn't be put in the prone position?
In the recovery
I'm
position?
sorry, in the recovery position.
I do not. So right there appears to be a strike that gets thrown. From the interviews, I believe it was, Mr.
But-
Jones.
Let's not talk about that.
Yes.
standing on the other side of that cell or door, right?
Mm-hmm.
Okay.
Is
And,
that a yes or a no?
Yes, I'm sorry.
That's all. I do that all.
and without going into what anybody said, can you tell us what appears to be happening here?
In my experience, having been in this same situation with other inmates, this looks like a human being's natural instinct to want to breathe more comfortably, and that he was trying to roll himself up to take the weight off of his chest.
We're starting again at 7 minutes and 8 seconds. I'm gonna pause here at 7 minutes and 31 seconds. Can you describe whether or not you see any use of force that's happened between, thus far?
Yes.
Okay, tell the jury what you see.
This appears to be two individuals pinning or securing a person to a floor after they've restrained him behind the back, which any type of stopping somebody from moving would be defined as a use of force.
And is it in compliance with the Shelby County use of force policy?
Right this very moment, or are you just asking in general since we've gotten to the 5th floor?
Since we've gotten to the 5th floor, the person is already restrained and there's still 2 people on his back and he's in a prone position, handcuffed.
I want to object, that's not in evidence again. There are not 2 people on his back.
Well, I'll let the witness testify to whether or not there are people on his back, and we'll be able, the jury to determine that, and then you'll ask that question again, please.
Does this appear to be in compliance with the Shelby County Sheriff's Office use of force policy based on the description that I gave before?
No.
Starting at 7 minutes and 31 seconds. Stevon Jones, he's got his hand behind his back. What does he appear to be doing?
Difficult to tell. If you could go back 10 seconds and play it again.
Let me ask it this way. Eventually, are we going to see leg irons put on Mr. Freeman?
It's difficult to tell exactly when they get put on, but yes, there does appear to have been leg irons placed on at some point during this altercation.
Is there a technique that you're familiar with for getting leg irons onto a person?
Either flatten the legs out and apply them directly at the back of the ankle. If someone's being hyper disruptive, crossing the feet at the ankles and pinning the heels up to the butt, bending the leg is effective.
We played it for a while until 9 minutes and 4 seconds. Is there any reason for this type of use of force to be being applied to Mr. Freeman at this time?
No. This person is restrained behind the back. They're face down. There's minimal to no threat imminent threat left in this situation.
Has he been placed in a recovery position at this point?
He has not.
And does that cause you any concern?
Yes.
Why?
It's been a prolonged engagement, and that's all the officers likely knew at the time, was that it's been a long engagement. Any human being on the planet would be tired, and it's imperative that we get the weight off of people, help their lungs open up fully, get them treatment for that chemical agent, and provide medical aid if necessary.
Starting at 9:04. And now what we just saw was Mr. Jones get up, and do there appear to be leg restraints now on Mr. Freeman?
Yes.
And seeing how Mr. Freeman's leg dropped, do you have an opinion about how those leg restraints were placed on? What method was used?
It appears that the ankles were crossed and the legs were folded up onto the butt, which is a not uncommon technique that I've employed myself.
And we're starting at 9 minutes and 10 seconds. Now that Mr. Freeman has leg irons on and is restrained with handcuffs behind his back and he's in a prone position, is there any reason to continue use of force?
No.
Do you see use of force, what's happening in the video right now?
Yes.
What do you see?
Officer Parham appears to be placing weight on inmate Freeman's back and securing him to the floor.
What should be happening right now?
Inmate Freeman should be moved into a recovery position. You can better monitor his health, move him into a seated position, ultimately to standing.
Are you seeing any struggle from Mr. Freeman?
No.
Are you seeing any danger to these correctional officers at this time?
No.
Has the objective been accomplished?
Yes.
Do you see them moving him into a recovery position now?
I do not.
Can you conceive of an explanation for why the person is holding Mr. Freeman's legs up?
I cannot.
Now, at 10 minutes and 50 seconds, we see Mr. Parham get off of Mr. Freeman's back.
Mm-hmm. Yes.
Has anybody moved him into a recovery position?
No.
Earlier in the trial, we heard that there may be a concern about PREA. About this situation due to privacy concerns. Can you tell the jury what PREA is?
Sure. So, PREA is the Prison Rape Elimination Act.
Wait, say that again.
Prison Rape Elimination Act.
Okay.
It's from 2003.
Okay.
Essentially, it is a federal law that is trying to lower or eradicate the amount of sexual assaults that are happening from staff on inmate sexual harassment, staff on inmate sexual assault, staff on inmate voyeurism inside of prisons and jails across the country. And we are all bound to abide by it. PREA, as far as correctional officers would be concerned in a use of force situation, whether or not a person is nude in the midst of use of force is irrelevant. For something to be considered a PREA violation, it would have to be unwanted, repeated, sexual in nature, and provide some type of sexual gratification. So whether or not it was unwanted that Mr. Freeman wanted them to touch him or not, if they were providing medical aid or trying to help him in some way. PREA would cover them under that guideline because it's not sexual in nature. It's not for sexual gratification.
Is there any way that this could be possibly construed, let me rephrase my question. Getting Mr. Freeman help in this moment, is there any way that that could possibly violate PREA?
No.
And what is more important, even if for some, I can't even think of how PREA would apply, but even if it did, what is more important? A life-saving measure or that?
A life-saving measure.
We start again at 10 minutes and 50 seconds. We just saw Mr. Freeman pulled up. Can you describe the technique that they used to move Mr. Freeman?
So it appears they hooked their hands underneath his elbows. Anytime anybody is restrained behind the back, any movement of the body when you're grabbing below the elbow line, so anywhere from here to here, essentially puts the person in a shoulder lock. If you don't know what I mean, that would be your arm rotating this way beyond what your shoulder is really capable of doing. If you don't have great shoulder mobility, you're heavier, you have injuries, it can be incredibly painful. And that's why we teach correctional officers, when you're lifting people, you don't lift them by the restraints, and you have to be supportive of the shoulders and the hips so that you're not hurting those joints when you're moving people.
And so that I don't have to pause it again in just a second, could this be in any way construed as moving him to a recovery position?
No.
Why?
Being knees and feet together in a kneeling position like that is not something that's taught as a recovery position. It's up onto your shoulder on your side or up into a seated, ultimately to a standing position.
Start again at 10 minutes and 56 seconds. Pausing here again at 11 minutes and 10 seconds. Now we see another movement of Mr. Freeman. Can you describe that?
It looks like they're lifting him. Again, they're pulling at the elbow line or below it, so they're putting strain on the shoulders. And it does not appear like he responds to the movement at all throughout this portion of the incident.
And what do you mean by that, doesn't respond to the movement?
If you did that to me, I would yell. It would hurt very badly. The fact that he is not responding in any way, not moving his head, not trying to get his feet underneath him to stand up, which is a pretty natural human instinct, tells me that he is likely not well.
And given that he is obviously visibly not well, what should be done in this moment?
Call for medical assistance, your emergency medical code, get them there as quickly as possible, roll the person onto their back. If you need more room or flatter room to work, you could transition the handcuffs from the rear to the front. Call for an AED, start CPR, life-saving measures if necessary, checking for breath sounds even before that, checking for pulses, talking to the person, a sternum rub if that's a part of their curriculum. A lot of things that could be going on that didn't.
Any reason, even if medical is called, to wait for medical to get there?
No.
Jury, why?
That's why we certify all of our correctional officers in first aid and CPR, because there are always going to be times that medical is short-staffed, or it may be a big building and it's just going to take them a minute to get there. And when you're talking about life-saving measures, seconds matter. And the ability to get an AED involved and to get CPR started sooner rather than later can be the difference between saving somebody's life or not.
Starting again at this moment. Mr. Freeman's head is fully on the ground, is that a recovery position?
No.
If he's completely dead weight, is that pressure on his chest?
It could be.
Do you see anybody giving him life-saving health care?
No.
And we just saw him pulled up that way again. Do you have any comments about that?
It just, it appears to be movement in the same manner that it was the last time they picked him up, not supporting the joints.
Now his head has hit the ground. Now his head has hit the ground. Have you seen anybody move to get him any CPR, put him in a recovery position or anything?
No. This is a version of a recovery position. We're now off of our weight is off of our chest. We're up on our shoulder, but there does not appear to have been any first aid or
Up
CPR
until-
rendered.
And my question was up until that moment.
Right.
Is he completely in a recovery position here?
No.
Does anybody appear to be closely monitoring him for his health?
It's difficult to monitor chest movement, breath signs from the rear.
Anybody checking for his pulse?
Doesn't appear to be.
Mr. Jones is standing right there. Did you see him give any health care to him?
No.
Is he in a recovery position yet?
No.
Is he in a recovery position yet?
No.
Anybody helping him?
It doesn't appear to be.
Yes. Can you pause the video for a second while we talk? You may restart.
Now we are finally seeing medical has arrived and are placing the AED pads on Mr. Freeman. Did you see anything that prevented any of the correctional officers from helping Mr. Freeman prior to this point?
No.
Mr. Miller, a couple more questions. Is that are the two different times that guarding against the danger of asphyxiation, that's in the Shelby County Sheriff's Office use of force policy. That's in there twice. Is that still taught?
Yes.
Okay, why?
It's important. It happens. It's going to continue to be a danger as long as we continue to have to put our hands on people that are being unruly or aggressive.
Right now, in use of force curriculums, is guarding against the danger of mechanical asphyxiation still taught?
Yes.
And why is that taught as a use of force policy?
Most altercations with inmates wind up on the ground. And the most common place to give yourself a tactical advantage to restrain people is while they are prone. So that is where the majority of incidents wind up, and that is where the majority of them go wrong, is once you are down on the floor trying to pin somebody down so that you can get their hands behind their back. And you get that tunnel vision, and you stay there for too long, put pressure in a spot that you shouldn't have, etc.
Question about what you saw with regard to Mr. Parham. That's the one with the green circle. Would you describe his knee placement on Mr. Freeman's back as intermittent?
No.
Why?
It appeared sustained, I believe I said in my report, for 3 minutes and 40 seconds.
And does that put somebody in danger for asphyxia?
In my experience, yes.
When Mr. Parham's knee was on Mr. Freeman's back, could you see whether or not he was actively resisting?
It did not appear that he was.
Do you have an opinion as to whether or not Mr. Parham and Mr. Jones stopped applying use of force after the difficulty was over? Or after they had gained compliance?
It appears that they continued to use force after Mr. Freeman had stopped resisting or posing an imminent threat.
Do you have an opinion about whether or not Mr. Jones and Mr. Parham's treatment of Mr. Freeman was proportionate to the threat that he presented?
It did not appear to be proportionate.
In what way?
They continued to pin him to the floor in a manner that kept him face down and didn't allow him for him to breathe properly when he appeared to show no imminent threat or active aggression.
Do you have an opinion as to whether or not Stevan Jones and Courtney Parham's actions on the 5th floor, as to whether or not their actions were objectively reasonable from a totality of the circumstances perspective?
I do not think their actions were objectively reasonable when you factor in the facts and circumstances that they knew or reasonably perceived at the time that they elected to use force.
If I can have one moment, Your Honor.
Yes, ma'am.
Your Honor, those are my questions.
Steve? Mr. Mason? Yes.
Yes.
And were those statements necessary for you to reach the opinions that you formed in this case?
No.
Yes, sir. You may ask your questions.
I'll look at that.
All right. ahead.
You testified on direct that it's important to have statements of the people that were there, correct?
Written statements.
Written statements. It's important to have them because the statements are given near the time of the event, correct?
Yes.
And that is something that you reasonably rely on as a use of force expert in forming your opinions as to what happened, correct?
Correct.
Okay. And as you testified to this jury, when you don't have incident reports, all you have is the video, correct?
Yes.
And had you had the statements of the other people, that would be something that is important to you because that is something that people in your field, experts in use of force, they rely on routinely, correct?
You're saying written statements?
Yes.
Yes.
Okay. And in your report, you offer what you relied on in this case. Do you remember authoring that report,
Yes, sir.
correct?
Just a second. I just want you to know, the jury's lunch is here. While we're handling this, is it all right? We just sit and give the jury lunch,
Absolutely.
and then we'll start back at 2 o'clock. All right, one of y'all just feed the jury lunch.
Okay.
Okay. Tell them they got till 2 o'clock.
further comments?
All right, Senator, you may ask an additional question.
Mr. Miller, I have one more question regarding the fifth floor.
Okay.
From the time that Mr. Freeman was knocked to the ground and correction officers, including Stevon Jones, put pressure on his back, to the time that Courtney Parham got off of his back, did it appear that there was constant pressure on Mr. Freeman's back?
No.
Pressure on his back placed by the guards?
On his back, like his up.
In the area where you would be concerned about asphyxia?
From the time, I want to make sure I'm understanding your
Yeah.
question. You're saying from the time he was taken to the floor to the time that a knee was placed there?
No, to the time they were on his back, to the time that Mr. Parham got off of his back, did it appear that there was constant pressure there?
On his back.
Yes.
I must be misunderstanding your question, but no, there was pressure on his legs where Mr. Jones was initially seated. And then there were the two other officers that were standing over the top of him, but whether or not there was constant pressure in between that phase of before Parham places his knee back there, no, I don't think there was, unless I'm misremembering the video somehow.
Let me rephrase the question. Was there pressure on his body while he was in the prone position?
Yes.
Okay. Thank you. And was it constant from the time frame that I just mentioned? From the time that Mr. Jones put pressure on his back to the time that Mr. Parham got off of his back? Was that pressure constant?
Yes.
And does that include the time that Mr. Jones was on the back of Mr. Freeman's legs?
Yes.
Thank you.
All right, you may proceed, Mr. Nancy.
Thank you, Your Honor. Mr. Miller, have you testified in this court before?
I have not. This is my first time.
You work at the jail in Nashville, is that right?
Not, I work for the sheriff's office. I worked inside the jails for 6 years. I currently work in administration in the training division.
So you're right now in administration,
In the training division, yes, sir.
training. What's the difference in administration and being on the floor?
Supervision level, direct contact with inmates. That would be, I would say, the biggest one is that direct contact with inmates. I'm no longer working a unit. I am teaching other officers that are going to work units.
And I was looking over your CV and wanted to ask you about a couple of the training certifications that you have.
Yes, sir.
In 2020, you took a mental health first aid,
Yes, sir.
and that class was it online or was it live?
It was live.
Okay. And how long was that?
That was an 8-hour course.
An 8-hour course?
Yes, sir.
Were you an expert after seeing that?
An expert after seeing that at mental health first aid.
Yeah.
That course was in addition to baseline mental health knowledge and de-escalation skills that I had been accumulating throughout my time.
Okay. Were you an expert in mental health after that 8-hour course? place or no place?
No.
And I'm looking at the training through AERCO, that's AERKO
Yes, sir.
International, am I pronouncing that right?
Yes, sir.
They are a producer of spray, are they not?
Yes, sir.
And they sell the spray, the chemical agent.
Yes, sir.
Do they provide you with in-house training there on how to spray?
Yes, sir.
When to spray?
When to spray, is that what you said?
Where do they teach you in those courses?
So, directly from ERCO is what you're asking?
Yeah,
So-
so that course that says Defense Options and Strategies from AERCO International.
So they offer a train the trainer course, where one of their international trainers, you can either go to them or they'll come to you. In my instance, he came to us. And we go over use of force policy, how chemical agent is applied in use of force, the differences in their chemical agents versus others, effects that might occur, post-care and medical follow-up, different things like that.
And what they're looking at is selling the spray as a lesser lethal option.
Less intrusive means, yes, sir.
And they give you a canister of that spray to use during your training?
Not during that training, no.
It was all just talking.
Well, no, I'm sorry. The instructor doesn't give me a canister, to answer your question as you asked it. I was directly exposed to spray in that class.
Yeah. I was talking about the training though. With the training, are you, was it a class where you just listened to the instruction, or was there application of what they were telling you?
There was no application in that class, no.
Okay.
That was where the agency, they left it up to us to do so.
Okay. To spray somebody, press down, I guess, on the sprayer, makes it shoot out, right?
There's an actuator on the top of the can, yes, sir.
You said you were exposed to the spray.
Yes, sir.
That one time,
Officially twice.
twice. And when you were exposed to the spray, was it during a class?
Yes, sir.
And was it in the room with other people?
Yes, sir.
And was it a quick spray?
No, sir.
Did it sprayed a whole lot on you?
About a 3-second burst.
That's a lot. That hurts too, doesn't it?
Yes, sir.
You said it had different effects on different people. We've heard that from other witnesses as well. But most of the time, it's used as an agent to bring someone under control.
Yes, sir.
You would start out with trying to talk to somebody, wouldn't you? Hey, calm down, everything's gonna be okay, we'll take you back down to the cell.
Yes,
Try to de-escalate the talking.
absolutely.
And if that doesn't work, you can move up to even grabbing, hands-on.
Soft-handed escorts,
Yeah.
for sure.
And from there, you could go to the spray if they would not comply.
Lesser lethal, less intrusive means, yes.
If you couldn't bring them under control. That's what you're trying to do, is it not? Bring them under control?
Gain voluntary compliance and bring them under control.
Voluntary compliance is nice in a book, but what if it's involuntary? What if that inmate doesn't want to be brought in compliance? That changes the whole scenario, doesn't it?
No.
It doesn't, okay. So your guys that are being, trying to round up this inmate, are thinking to themselves, I wonder what passage 8.062 tells me to do.
Probably not.
Probably not. They're in real time, aren't they? They're responding.
Yes, sir.
There's a big difference between reading it in a book or telling somebody about it and being in the middle of it.
Since I have done both, I would agree with you.
I'm gonna look over this video one more time. Can you see it okay from where you are?
If the judge doesn't mind if I look over his head again.
Right ahead. The way that you would.
No, sir, you're just fine.
Thank you. Sorry, buddy. This is down on 4th floor, is it not?
Yes, sir.
And is this the officer speeding?
Appears to be.
Okay, stop it one second. Courtney Parham, he's not down there, is he? Stop it.
It doesn't appear to be, no, sir.
Do you have any information that Courtney Parham controls or has input into whether or not, or and how they feed?
No, sir.
Well, does Courtney Parham, to your knowledge, have any information, any input, any authority to tell them how to serve the food?
Not to my knowledge, no, sir.
What about using the flap versus rolling the door? Does he have that authority to tell them, it's okay to roll the door, go ahead and do it?
Not to my knowledge.
Go ahead, please. Coming to Ms. Freeman's cell now.
Yes, sir.
Now, does that man look psychotic to you?
He does not look well.
And now he's attacking the officer. And he hit the officer, is that right?
Yes.
Good. And the officers are trying to get him down, they're hitting him back.
They have gotten him down.
They've gotten him down. He's down. Is he laying still?
He is not.
Back that up just a little bit, please, Ms. Hicks. I want to go where you can see his back. About that. Okay. A little bit more. Officers. Okay. Right there, you can see spray on him as well, can't you?
Yes.
Is spray slick?
Can be.
Is spray oil-based?
It is not.
It's not.
The oleoresin capsicum, I mentioned this earlier, the OC is the oily extract of the capsicum pepper plant.
You're
But
saying that, I'm sorry.
No, please.
You're saying the spray is not slick?
Those are two different questions.
Okay, well then let me re-ask that. Is the spray slick?
It can be, yes, sir. Absolutely.
Does this spray appear to be slick?
I would say so.
Okay. Long journey, short trip. Mr. Freeman is on the ground right now, right?
Yes, sir.
And spray is in the air,
Yes.
all right? And is he being compliant?
No, sir.
Is he obeying any orders that they're being given?
If they're being given, it does not appear so, no, sir.
Do you see Courtney Parham in that crew?
I'm under the assumption that our green circles are accurate, so no, I do not.
And Stefan Jones isn't there either, right?
If, again, same assumption for yellow circle, then no.
These officers are surrounding the person, is that right?
Yes, sir.
And he just got out, right? He just got out of his cell. He just tried to run down the hall and fighting with officers, right? And now he's down on the floor.
Yes.
So at this point, the officers know whether he's going to comply with them or not.
I would say a reasonable officer would expect that he was not going to comply with directives right now.
And he's still squirming, his feet are slipping on the ground, right?
Yes.
Stop. And your assumption is right, he is still fighting the officers, correct?
Yep. Yes.
That your information, this spray was, heavy on fourth floor.
Yes, sir.
Now, at this point, stop. At this point, Mr. Freeman is down, right?
Yes,
And is he being struck?
he is. It appears to be.
And is he still fighting the officers?
He's at a minimum still moving.
Let me show you right here, yes. That his arm, grabbing the officer's leg.
Could you play it? I mean,
Could be, could. That's where he is, that's his general area. Has any of these officers right here, Courtney Park?
does not appear to be.
To your knowledge, does Courtney Park even know what's going on there?
No.
Now, is the officer, is Mr. Parham under control at that point?
No.
Is he still fighting at that point?
He is still moving at that point.
So he wasn't complying at that point. He's still struggling with officers,
Yes.
trying to get up and look like get away. But I think
Perhaps.
he's gotta get him to let me go back to my cell.
Maybe he's defending himself from getting hit.
Is that what it is now? He's defending himself.
Maybe. It's, we may never know.
And he's defending himself because he ran out and hit an officer, right?
The officers had a duty to respond initially. Absolutely.
Now, these officers are in real time, right?
Yes.
They were watching it happen. Air's full of spray, and Mr. Freeman is covered slick.
Okay.
I believe the autopsy report said he was around 180 pounds, 5'10", 5'11", 5'9",
Okay.
pretty stout up.
All right.
Didn't look fat to me, did you?
No.
And he's fighting the officer.
He's struggling.
He's struggling. Okay. Oh. Now, what is this officer doing? Stop it a minute for me. What's that officer doing? Is he? I'm the one to find that.
I do not know.
Well, let's say, is it consistent with him choking because of spray?
Yes.
What else is it consistent with?
Crying.
Huh?
Crying.
So is it between choking on spray or crying, which one do you think's more possible? Probable.
It's hard to say. He could have simply just been tired, trying to catch his breath.
Ask yourself, when
Consistent
you're
with that
asked
as
to
well.
give your opinion, is it a neutral something where you view the evidence and you're neutral, you're not favoring this side or anybody else's side, you're just giving your opinion.
I like to look at all possible outcomes.
So you're telling this jury that it's really possible this person is a crime.
Maybe. Maybe they got popped in the nose by an
That's
errant
your
foot.
opinion.
All right, don't y'all, Mr. Massey, let him
Yes, sir.
finish his sentence before you ask him another question. We don't want y'all talking at the same time.
All right. Move forward from Officer Crime.
I was finished, so I'm sorry.
Either one of those officers you see Courtney Pond,
No, sir.
that guy coming up the hall, the Courtney Pond,
Doesn't appear to be.
there comes Courtney Pond, right?
Yes, sir.
He walks out of the screen for a moment. Now, here he is again. Mr. Freeman is nowhere in sight in this picture, is he?
Correct.
And Mr. Parham, can you tell what he's doing?
Moving backwards.
Is he acting, is what he's doing consistent with moving a fellow officer that's been sprayed down the hall to where he can get him, to get his eyes cleaned out?
Is it consistent with it?
Yes, it's consistent with it.
So,
So you don't really know what's happening there, right, other than you see this picture. You're
Sure.
giving this jury your perceptions of what is going on.
if I'm moving somebody out of an area, I would typically be the one moving forward. So if I'm Courtney Parham and I'm walking backwards, I don't know that that's consistent with moving somebody out of an area.
Leading this guy?
You could be, but you still want to see where you're going.
It could be, it couldn't. It depends on how you're looking at it, right?
It just
And
depends on
how
what's.
you're perceiving it,
Sure.
and what opinion you want to give the jury. Oh,
Okay.
okay. I want you to watch the top left corner. Hmm? Yeah, okay, yeah. Right in here to see these cameras that are taking these videos.
So when you say right in here, he's not looking at that screen, Mr. Massey, he's looking up here.
I understand.
So we can have him step down if you want to.
I'll just ask him from this screen.
All right,
Yeah, I
thank
think they're showing the very same thing. Ms. Stoops, would you roll this please to where there's pierced right here? Is that it? Back it up. So.
Sorry, that's my fault.
I think you got it right there. Now, something got on that camera, right?
You're saying from the,
You might can see it better down here. You want to step down and look with it?
I mean, if you're.
Yeah, that's what I'm-
Just make sure you speak loud since you're away from your microphone.
Yes, sir. We're talking about here.
Right here.
Can we agree
Can you back it up and run it again for me? Okay. Right there. See it?
Yes, sir.
Okay. That's consistent with sprayed and, getting the camera?
Could be, yeah.
And did you see any officers spraying?
Can we watch it again? I'm so sorry. I don't see anybody spraying. It's difficult to know where it came from.
There's room back here though, isn't there? We can't see. Here, back down the hall this way. All the officers are down there, right at the other end.
I'm confused.
Okay, come down here, that's it.
You're saying there's room down.
This hall right here. It keeps going.
Okay.
And all the officers are down at this end, right?
That's not where they come from, though. That's an adjacent unit. They come from further down this hallway underneath.
Where does Gershun Freeman come from?
Right about here.
So we came down this hall. And there's an officer's got spray. That's after we've already seen what I'm getting at. Let me just get to the point I was asking. Yeah, there's Mr. Freeman.
Yes.
See him, Mr. Freeman?
But again, he came from here, not from over here where you originally said. That's a different unit.
Do you agree with me that this hall goes down this way?
Yes.
And would you agree with me that when he came out, he came from down this hall?
I don't think you can say it came from down there unless you know exactly how the jail's laid out. He came from down here.
Okay.
He comes from off screen down here. I'll agree with you there.
He comes off from off screen with his arms around the officer's leg. Right?
Yes, sir.
Do you know if he bit that officer?
I don't.
Do you know if he bit any officer?
I don't.
Did your investigation reveal he bit any of the officers?
I don't recall.
That would be important, wouldn't it?
It could be. Biting is a problem.
I'm sorry?
Biting is a problem. It is something that happens in jails.
Doesn't it?
Biting is also something that correctional officers typically do to themselves, as much as we don't want to admit it. If I don't put my hand in front of your face, you can't bite me.
So what should these officers do? Just back up and let him run free into jail?
Put your arm somewhere else.
That way-
Control the hips.
That way he wouldn't be hurt.
Mr. Massey,
Yes,
when he's answering the question, you need to wait until he's through, please.
yes, sir, thank you.
That's
What was your answer?
that's where you control the hips, you control the shoulders. Again, if your arm's not across somebody's mouth, you're not in any danger of getting bit.
So at this point, it's safe to assume that we've already gone through trying to talk him down. Isn't it? It appears to be.
Yes, sir.
So yeah, that's what it is. It appears to be.
Yes, sir.
And it appears to be officers have already had hold of him, and nobody could keep him, and he took off and got away from them all.
I disagree with you there.
You disagree with he got away from him?
He got away from them
Okay,
because they allowed him to.
okay. Well, they got around him, right?
Yes, sir.
He's covered with that spray.
Yes, sir.
Some of them were either crying or choking from the spray, the officers.
Yes, sir.
But it didn't seem to be affecting Gershun Freeman, did it?
Not as much as other people, no.
He was having a psychotic episode or something,
It could have been.
consistent with it in his actions. Fighting crazily, what's his purpose?
You, fighting.
Yeah.
You keep using that word.
Cool.
Once again, I'm not 100% sure what the question was or what the answer was, because Mr. Massey was talking to us.
Yes. Ms. Massey, if you just let your heart beat a couple times, let him finish before you ask another question, please.
Yes, sir.
I'm sorry, ask your next question. We were in the same spot.
I'm not sure what about the Okay, let's talk to you. Now, the fall was so slick, one officer fell, right?
Yes, sir.
And there goes Mr. Freeman. There goes the spray. He got a good spray right in the face.
Yes, sir.
Is Courtney Farm anywhere there?
Again, assuming our green and yellow circles are correct, I don't see him.
Now, at this point, Mr. Freeman is down prone on his stomach. He's now raised up, went through that door, right?
That door on the left, yes?
Yeah.
Yes.
Well, you've got another officer now, right? Another Laird?
Yes, sir.
Is he complying?
Depends what they're telling him to do.
Does he appear to be complying to you in your unbiased opinion, sir?
No,
Does he appear to be under control?
no.
Go ahead. You see Mr. Parham or Mr. Jones anywhere in that crew?
No, sir.
This is fourth floor, right?
Yes, sir.
Okay, this fifth floor? Still on floor. Now, there's Mr. Farm. He is walking backwards, isn't he?
Yes, sir.
He has an officer by the arm, does he not?
He appears to.
He's leading, and it appears.
He could be, yes, sir.
Is that consistent with the officer having spray in his eyes and Mr. Parham helping him get to an area where he can clean his eyes out?
Yes.
Mr. Jones is nowhere in that picture, is he?
I do not see a yellow circle, no, sir.
Well, at this point, did you see anything Mr. Parham said here? Stop a minute. What's Mr. Parham done?
Responded and helped somebody out?
Has he done anything wrong at this point?
Not that I've seen.
It appears these officers are struggling with somebody, doesn't it?
Yes, sir.
Over on the right side, and Mr. Parham goes over and utilizes the spray.
Yes, sir.
He just kind of walks off, doesn't he?
Yes, sir.
You know why he didn't just go back to his cell?
Nobody made him.
He wanted out, didn't he? He wanted away from that cell.
Or maybe he wanted away from the people that were hitting him.
That's safe to assume that he didn't want to go back to that cell, did he?
Most people don't.
And the answer is yes. Safe to assume that he didn't want to go back to his cell.
I can't speak for him.
You can speak against him, though, can't you? It's number 4, that Courtney Farm again?
Where the green circle?
Mm-hmm.
Yes, sir.
Okay.
Again, assuming the circles are correct.
And he's not touching Mr. Freeman.
No, sir.
Mr. Freeman is going up the escalator. Right,
Yes.
there you go now. See that patch on his back?
I do.
You know, he got stabbed before he came into jail,
I did read that in the medical examiner's report.
and so Mr. Parham is down in this area, away from, Mr. Freeman at this point, isn't he? Stop it. Mr. Freeman hitting, swinging at the officer.
He appears to take a swing, yes, sir.
Is it okay, I think I've asked this, but I want to be sure. It's not okay for Mr. Freeman to be running loose through the jail,
No, sir.
much less in a disturbed mental health state,
Correct.
covered with spray.
Dangerous for everybody.
And acting consistent with his psychotic break.
Objection. Calls for speculation. He doesn't have the qualifications to answer that.
I believe that's beyond his expertise, Mr. Massey.
Acting disturbed mentally. You
Yes.
went to the mental health class, right?
Acting disturbed.
Now, Mr. Parham isn't here at this, between this officer, not Mr. Parham, right?
Correct.
Okay, right. And here's three officers. They're trying to, is he complying at this point? Is Mr. Freeman complying at this point?
You are confusing compliance with being a threat.
You're gonna have to repeat this for me.
You are confusing compliance with being a threat.
Ah. So these officers are threatening him.
How quickly can self-defense turn into an assault?
You're saying these officers are threatening him?
I was just asking a question.
I'm asking you a question.
I'm saying that you're right, I apologize. I don't mean to be so argumentative with you. He takes a swing. They have a duty to respond to that. They strike back, they get him on the floor. I have no problem with anything right there. Why do they continue to hit him once he is on the floor?
Was he complying? Was he being still?
Was he, the relevant question is not whether, I'm in my line of work, I don't mean legally, I apologize. The question is not whether or not he was complying, it's whether or not he was a threat.
Was he under control?
He was not under control.
Go forward, please. At this point, he's down, right?
Yes, sir.
Okay. He's still trying to get up. See him right there? Raising up?
Yes, sir.
Okay. So he's still struggling, is he not?
He is struggling.
He doesn't want to give him his hand. Right?
Very common.
Go ahead. Mr. Parham is not in that video at this time, is he?
Correct? There.
There comes Mr. Parham.
Good timing.
Go ahead. Okay. Nobody's hitting or kicking him once they have him down in control, are they?
Correct.
Go ahead. Now, did you know what's being said there?
I don't.
Mr. Jones appears to be straddled at his leg back behind him. His hands are now cupped, it appears, right?
Yes, sir.
So Mr. Jones is sitting on his legs,
It appears so.
and there's nothing wrong with that.
Correct.
Okay. Now, at this point, he's down, he's on his side, as a matter of fact. Isn't he?
Yes, sir. He appeared to move himself there.
He's still fighting, he's still squirming. Or did they put him on the side?
He appeared to put himself there.
Go ahead. Okay. Now, at this point, Mr. Parham has this, what appears to be his right knee in the man's back.
Yes, sir.
And Mr. Jones still appears to be straddled with his legs. Fair enough?
At least in an S mount, he may be up on one foot, but yes, at least partially straddled.
Go ahead, please. Oops, there he is, he's struggling again, isn't he? Stop it, please, we need to run it back.
Please.
Wiggling still trying to wiggle away. Or maybe he's just wiggling, I don't know, he's wiggling anyway.
He's moving.
Okay. Still moving. Is it your opinion that's what the officers are wanting him to do?
They're wanting him to move.
Yeah.
They want him to no longer be a threat.
They want him to be still and be under control, right?
You can
They don't
be
want him to be trying to get away, do they?
sure.
They don't want him to be moving and squirming and fighting with him, do they?
Those are three different questions.
The answer's no, to each one of them, isn't it?
Do they want him to be fighting? No. But he's not fighting.
So sorry, guys.
All right.
Came through my computer.
At this point, only two officers are there. Right?
It appears so.
And you know if they're DRT members?
Say that again. I'm so sorry.
You know if they are both DRT members?
I don't.
Do you know what DRT is?
I would imagine it's some type of a CERT team, but I don't know what the acronym stands for.
Got an opinion on this about DRT members and you don't know what they are? You don't know what DRT is?
I'm so sorry. If you could.
I was just wondering if that's. Do you know what the function of DRT unit is in the jail?
Not off the top of my head, no, sir.
If I told you it was to deal with hostile inmates, would that be important to you? Is that an important fact?
Yes, sir.
Is it something you didn't know?
I understand what a team like that would be. I'm sorry, I'm looking for it in my report, and I don't see
Before
it.
you wrote your opinion, did you do any kind of research on DRT?
I mean, I have a sort team at my own agency that we employ in times of crisis. As far as a team that is in the jail at all times, that is not something that I'm familiar with.
These officers, they're familiar with the extra training they have to do the hard job they do.
So, if I'm drawing comparisons to a
And one
DRT,
necessary part,
to-
Are you familiar with the extra training that these officers have to do to become DRT members?
no,
Is that important
it could be,
in the decisions they make?
yes.
My objection, Judge, is that Mr. Massey said yes or no, but then he didn't allow him to then give his full and complete answer. He just went on to his next question. I just asked that the witness be allowed to give a
Let
complete
him
answer.
complete his answer. He does not understand what the acronym DRT means. So you understand that is the witness. You may finish your answer, sir.
Yeah.
You have one to think.
I don't.
Okay.
Go ahead and roll it forward. I stopped it for a second. Is there any way you can tell, looking at Courtney Park, he's got one knee out to the side and one knee on the back of Coach Freeman.
Okay.
Any way you can tell how much weight he's putting on both legs, either leg?
How much weight? No, sir.
Did you agree with you that you can put a lot of weight on that knee? Or you could put a little weight on that knee?
You can do both.
So what was in their mind at the time would be important.
Yes, sir.
I want to look with you 1 second at I think it's exhibit 11. And it's on page regarding putting it in section N. And it says inmates may not be placed face down in a prone position while in restraints.
I'm so sorry, Mr. Massey. Is this in the policy or is this my
It's in the
report?
policy.
Okay, can you tell me what page you're on?
The witness is showing
Now,
right here.
Coach, you showing?
Yes, sir.
Okay, so you're on page 6. Yes, sir, go ahead.
Inmates may not be placed face down in a prone position while in restraints. At this point, the hands were restrained,
Yes, sir.
the legs were not.
Okay.
Right?
I believe I said it in my report. It's very difficult to tell exactly when the leg irons are clicked on.
Well, as Ms. Fuchs pointed out, the video sometimes is not of the best quality.
Sure, for sure. Yes, sir.
Inmate may not be placed face down in a prone position while in restraints because of the possibility that they may be unable to breathe properly.
And
Okay.
asphyxiate.
Everybody can agree with that, right?
Yes, sir.
And that's the policy. And asphyxia, asphyxiate, mean they couldn't breathe. I have to ask you, anywhere in all the evidence that you've looked at, have you seen or read anything when this man says, I can't breathe, I can't breathe?
No.
Policy reading further, it says if an inmate must be placed face down in a prone position, he must be observed continuously, and employees must exercise great caution when placing their body weight on the inmate face down. Right?
Yes, sir.
So it's not saying you can't use this position, this knee in the back, right? You can use that position of knee in the back. You gotta be careful about
Yes.
it.
It is giving you a guideline saying that you need to be careful when you use it.
Yeah, that's what I was reading to you, right?
But
And we agree with that, right?
you've left off the last line of that policy, of that section of the policy.
Well, you can read that for us, I'm sorry.
It says, once staff has gained control and the inmate is compliant, this position must be changed as soon as possible.
Okay. Once staff has gained control and the inmate is compliant, this position must be changed. What was that last part?
As soon as possible.
As soon as possible. Okay. So at this point, he's restrained, he's under control, and do you know who these guys are?
Not off the top of my head, no, sir.
Are you familiar when your research for this opinion with Lieutenant Cleves,
I've read that name, yes.
who was head of that role?
Okay.
And if Lieutenant Cleves told Stephen to go get leg restraints
Stephen is Jones, correct?
and told Courtney to stay right there, make sure he didn't have her or not, then that's what Courtney should do, stay right there. Follow the orders, it's security, right?
You are legally required to follow orders so long as they are lawful and reasonable.
We'll see if Mr. Jones gets up. Okay? Stop for 1 second, please. Mr. Parham is looking down at Mr. Freeman the whole time he's on top of him. He's keeping an eye on Mr. Freeman. You need to run it back.
He could be, yes.
Okay, let me put it another way. His face is facing Mr. Freeman as he's down on the ground in a manner that's consistent with him watching him.
It appears to be.
And you agree with me on that?
Yes, it appears to be.
Now Mr. Jones has left, leaving Mr. Parham, right?
Yes, sir.
You've got 3 officers there. Is anywhere in your report does it indicate that those officers saying, man, we need to get medical up here, we need to get them up and they roll them on the side to a recovery position, we need to do something to help this guy out?
No, sir.
And you still don't know how much weight's being put down, right?
Correct?
There's a lot of weight, it's not good. If there's not as much weight, then that would be compliant with policy, right?
Would it be compliant with policy if it were not as much weight?
Right.
there are better alternatives for you to place your weight onto somebody to keep them on the floor that do not involve the upper back.
You know, a better play the football team could run on Sunday. And on Monday, the second guessers are looking back saying, you should have run this play. There's better ways to do that. You're second guessing these officers that are in real time. And you're doing it while sitting in your suit on the chair. in the
Sure.
Comfort of the jury.
And that would make it odd, except for I've been in those situations myself. I've placed my knee in the back of a naked, unruly inmate who just got done punching one of my friends. I have had altercations very similarly to this that did not end the same way.
Death in custody cases are different, aren't
Of course.
they? Have you had one?
Have I had a death in custody case, not from a use of force? I've had several suicides.
No, I remember you sports.
No, sir.
So you're giving your opinion to the jury today about what these officers are doing based on something you've never done before?
I have never done it because I have been trained not to.
Go on, please. Now, Mr. Farm got up, didn't he?
Yes, sir.
Leg shackles are now on, Mr. Freeman.
I'm sorry, say that again?
The leg cuffs are now on Mr. Freeman.
I,
You gotta run it back so you can see him do it.
so I may have misunderstood. I thought you were saying the leg irons were just placed on Mr. Freeman when Mr. Parham got up. It appears they were placed on right there, and that's why Mr. Jones gets up.
Mr. Farm was the one I'm asking about.
Yes, sir. Okay.
And did you see him put leg irons on?
No, Mr. Jones appears to put the leg irons on.
Okay, they're wearing the wraps for him now. All right, thank you. And Mr. Farm is off of it.
Yes.
And you'll be allowed.
I don't
Look at
know.
his head. Keep on going. There. Did he raise his head up there a bit?
Can you play it again if that's what you're saying there? It's-
There.
When they lift him, yes, his head raises.
Did your report indicate? report indicate anywhere, any of the information you used in making this opinion, that Mr. Parham, while on his back, said anything to indicate, hey, I know I'm probably killing this guy, but I'm just gonna sit up here.
No, sir.
Officers have a hard job, don't
Yes, sir.
they? Now, give me 1 second, please.
Yes. Don't need recess. All right, let's take recess, ladies and gentlemen. Just take recess, anything else? Go back in 2 minutes. please.
Court's back in session.
Are we ready for the jury? Bring jury in, please.
Jury's entering the courtroom.
All right, thank you. Again, we're gonna start back, ladies and gentlemen, but first I wanted to talk to y'all about your questions. Periodically get questions from the jury. You can ask questions about if there's something that you heard that you didn't understand. What was that? We haven't handed out the vaccines yet. We get a lot of questions about that. You can't ask questions about the case that aren't put on as proof. You can't say, like, for instance, if there were a drug case, what color was the package? You can't ask questions like that. If the attorneys want you to know, they'll do that. Or, I know the officer said the car was red that he was driving in, but wasn't it really yellow? Or why didn't you ask the other witnesses that? We can't really let you guys be attorneys in the case, because they're gonna decide what proof to put on. But if there's proof that's put on that you can't understand, like if somebody talks about the color of something, but you really don't understand what they said the color was or something, you can ask questions like that. We're gonna let the attorneys decide what proof to put on. Another question, are you gonna put proof on about this? We can't ask those kind of questions because that's gonna be the lawyers to make those decisions. But if proof is put on that you do not understand for some reason, you hear it well or something like that, just let us know. All right, Ms. Massey, make it.
Before it also advise the jury that when a witness adopts a statement I've made, that's evidence.
Well, if the witness says yes or no, and I explain that to him, if you say it's 2 + 2 is 4, it's not proof unless the witness says yes, then you can either believe or not believe the witness. All right.
Thank you, Judge.
Yes.
You were, I believe you said you looked at medical records in making your opinion.
I did.
Okay. And did you also read Garrity's statement?
I'm not entirely familiar with what a Garrity statement is. I do remember seeing it in a report somewhere.
Garrity's statements would be what came from all of the officers that were there on the floor. Did you not look at what they had to say?
I looked at everything that was offered to me by the state.
Do you recall being provided medical records from Deputy Davis about getting fit? You have to go to the doctor.
I do not.
Sit on her butt.
I do not.
Okay. In looking to see how many of these questions I've already asked.
Yes, sir.
The policy provisions that you cited in your opinion, and the council put up on the video for it. They describe routine documentation requirements,
Yes, sir.
and these provisions that you told the jury about, they do not address how documentation is handled in during a criminal death investigation. Did you get my question?
I don't.
Okay.
I apologize.
Those policy provisions that you looked at, that were Shelby County Sheriff's Office policy provisions, they do not address how documentation is handled during a criminal death investigation. Those are general policy statements,
Sure.
right?
If there's a use of force, there should be written reports by all the staff involved or that witness it by their own policy. Whether or not there was a death afterwards or not is irrelevant.
And you said you weren't sure about Garrity's statements of what they were, is that correct?
So statement that you make that can't be used against you in criminal proceedings from my basic understanding.
And Garrity exists to prevent officers from being compelled to give statements, right? That could be used against them criminally.
Yes, sir.
That somebody could come way later on and say, hey, you did this.
I'm trusting you're telling the truth.
Judge, can we approach?
Yes.
You're familiar with the Constitution of the United States, you realize we have Fifth Amendment rights,
Yes, sir.
is that important?
Can you remind me, I'm sorry, it's been a long day, what Fifth Amendment says?
I understand. It's a right not to be compelled to give evidence.
Speak out against yourself.
Right.
Yes,
right,
sir.
Right.
I'm familiar.
Either for or against.
Correct. Okay.
And the state has that same protection, state of Tennessee, in its constitution. You familiar with that?
That would be Garrity laws.
That's why Garrity can't be used against someone as an officer.
Okay.
Okay? Because of their Fifth Amendment right and their state constitutional rights.
Okay.
Very balance of that. And
Sure.
those constitutional rights are important.
That makes sense.
Do departments often delay or prohibit routine written reports in death in custody cases?
No.
And that experience, the answer is based on what?
My personal experience at my agency,
In your agency?
conferences I've been to, friends that I have that, and peers that work in other agencies throughout the state.
In death in custody cases, is it common for outside investigators to conduct recorded interviews rather than rely on incident reports?
I believe so. You say rather than rely on incident reports, I would say in addition to written reports.
And that kind of allows the investigators to control the question.
It could.
And that's not acknowledged in your investigative, that your report does not acknowledge that that is a common investigative practice, does it?
Correct, I'm not an investigator.
Did you talk to anyone to say why you didn't get any reports, incident reports?
From Shelby County? No, sir.
Did you just investigate this case based on what you were given by the prosecutor?
Using my extensive knowledge of use of force in general, when I was approached about the case, I asked for several items that would allow me to investigate it, to which include incident reports.
We were able, in looking at the video, we're not gonna look at it again. We were able to stop it, back it up, run it forward a little bit more. We could break it down frame by frame, right?
Yes.
The officers could not do that on October 5th, could they?
Correct.
They were in real time.
Correct.
They were responding. Would you identify, please, the exact control technique that Deputy Parham personally could have used, given the chemical impairments from being the spray all in there, and a subject that was wet, naked, and squirming? What are the exact control techniques that he could have?
You say identify, like, are you asking me to
You want you to identify.
do it on somebody, or simply talk through it?
You can do both, yeah, it matters not to me.
Sure.
Whatever will help the jury, but.
So if I have somebody who is down on the floor, hands cuffed behind their back, and I need to get them into a secure location, if I still need to keep them pinned, I can put pressure on their lower back with my rear leg. I can put pressure on the butt. I can put pressure on the hamstring to help secure them down. If I'm really struggling with the upper body, because when hands are behind the back, your arms flare out a little bit, as you can see from behind. I can take my front leg and put that knee into that kind of elbow pit area. It's relatively painful, but it will get some pain compliance and keep the person down. Eventually, what I want to do, once I feel this is no longer a threat, ramp it back down, I have control. I'll take my my lead hand and cup the head. I'll take my far hand and grab an elbow, and I'll pull the person into me in exactly this position. And I've done this a couple hundred times in my life. If I can hold this arm up here, remember these hands are cuffed, I can support the head, and I can really see the chest falling and rising. I can see the person breathing. If they start to get so rowdy, again, I can put that knee inside of that elbow pit, and I can separate the hands, and that keeps them in that recovery position. But it really starts to separate. Eventually, because this arm is hooked, I can just set them up into a seated position. I'll lean them back against my shin. Eventually, I'll get somebody else and we'll stand the person up.
Thank you.
You're welcome.
said you weren't familiar with the current DRT.
Correct?
So are you familiar with their training?
Not entirely, no, sir.
The knee in the back, and I was asking on fourth floor, but your answer was really geared toward fifth floor, wasn't it?
Yes, sir.
Okay, that's fine. The knee in the back is okay to do when there's a problem, but you gotta be careful. Is that right?
Correct.
So it's not against policy as long as you're careful,
Their policy says you have to be very careful.
very careful. And to be careful, you would want to distribute your weight so you don't have too much weight on the person. That would impair their breathing, right?
Okay?
And you want to watch them. That's the two things that the policy addresses.
It
Does
does.
not?
It does.
And we talked about this earlier.
Judge, I believe the witness was about to complete his answer as he reached for paperwork.
I'll let you.
If we could make that clear.
Well, I'll let him answer that question before you ask your other question.
I just wanted. We are still, my issue is the way we're phrasing these things, right? We want to make sure we're actually meaning what we say. So, does the policy explicitly prohibit that knee in the back? No. I think you and I both agree on that. Is it something that is allowable to do as long as you are being careful and you are watching the person? Yes, I think that is trained. That's trained in this PPCT, which is the defensive tactics program that Shelby County advertises that they utilize. And it is something that has worked for many, many years. The issue is the last line, which we're again leaving out. Once staff has gained control and the inmate is compliant, this position must be changed as soon as possible. And that is where you need to move into other reasonable alternatives, moving your knee off of the person's back, getting the person out of the prone position.
And is that your opinion after looking at this years later?
Yes, sir?
And if you had a senior officer that told you to remain on that position to keep them down, and when the officer told you it's okay to get up, that's where as soon as possible would be, when the officer tells you it's okay to get up.
It doesn't say as soon as possible or when your supervisor lets you. It says when the inmate is compliant as soon as possible. There are ways to keep somebody down and secure. I'm sorry, we keep interrupting each other. There are ways to keep somebody down, secure, and relatively still that don't involve putting pressure directly on the back.
Right. And you would agree with me, would you not, that the knee in the back does keep a person from getting up?
Yes.
And even you have to put a lot of pressure on somebody.
So does,
To keep them down.
so does a knee right across your ankle bone.
So it's a better practice that you're looking at, something that's in the book.
There's a reason it's such a better practice. Shelby County knew that because they put it in their policy twice.
And there's a reason that it's different when you're in real time versus reading a book.
Sure.
And you're not telling this jury, are you, that Mr. Parham should have said, I don't care what my officer told me, I'm gonna just get up.
No, I don't think Mr. Parham should have just gotten up. I think he
And
should
so
have.
Mr. Parham showed
Judge,
us to.
once again,
You have to make sure he's through this.
That's my fault. You turned around. I'm sorry. I think Mr. Parham should have maintained control even while Mr. Freeman was on the floor, but he should have been moved into the recovery position. Which, if you're telling me they are DRT members and they have additional training, stands to reason they should be trained how to do that.
At that point, when Mr. Plum, John had his knee on him. Did you have any information provided to you to reach your opinion, to assist you in reaching your opinion, that there were other officers there who said
Objection, Your Honor.
that there are other officers there, who voiced concerns about him, and it looked like
Objection,
he
Your Honor, this
might be
is-
killing him.
Yeah. Let's not talk about what other people voiced, Mr. Massey,
I'm not gonna go into what was said. I'm gonna
Well,
ask
you
for-
did, you said they voiced concerns.
Yeah,
Can I
voiced
put a brush
concerns.
on that?
Yes.
In reaching your opinion and using the information that you were provided, did you receive any information that other officers voiced concern about the, whether or not Mr. Freeman was about to die?
I do not recall specific statements or concerns from other officers in those statements when I was forming my opinion.
When you were watching the video, did Mr. Freeman, was he examined by, on more than one occasion by medical personnel after Deputy Plum got up?
Yes, you can see medical arrive.
Can you identify for the jury the moment in which Deputy Parham stopped monitoring Mr. Freeman?
No.
Would it be fair to say it was when he got up?
Sure.
He was no longer monitoring him closely, was he?
I would say so.
But he moved away.
That's fair.
Now, you're not a medical doctor, right? I'm not either. Neither one of us are medical doctors, right?
We agree on that?
And you didn't conduct the autopsy.
Correct?
And you can't medically isolate Deputy Parham's actions as to the cause of death.
Considering I'm not a doctor nor a pathologist, no, sir.
So the answer is no, right?
Correct.
And so your opinions you're giving the jury today, they're based on assumptions you make from watching the video about what officers perceived in real time.
That's how we review uses of force, yes, sir.
Here, please. Thank you. No further questions.
Sure.
Thank you, Your Honor. Mr. Miller, good afternoon.
Good afternoon, sir.
Jack Irvin, I represent Steve Jones.
Yes, sir.
I'd like to start by finding some common ground with you, some things we can agree on.
Okay.
One of the things you said this morning that struck me is that as a use of force expert, the more information you have about an incident, the better, right?
Yes, sir.
And I believe what you said is it's important to have statements near to the event of the people that were there, correct?
Written statements, yes, sir.
Written statements, that's what we're talking about. Yeah, I think you said what they were feeling at the time, correct?
Yes, sir.
And when you, this is what you said, when you don't have incident reports, all you have is video.
Correct.
And you can't get a good idea, or as good of an idea, based on the video when you don't have the written statements of the people that were there.
Correct.
That's fair, right?
Yes, sir.
All right, let's talk about what you did have, okay? And your report is in evidence, they can look at it. You had video of the incident, correct?
Yes.
How did you get that?
I was given it by the state.
Okay, do you know particularly who at the state? Was it emailed, was it handed over, did you meet with them?
It was given to me on a flash drive.
Flash drive? And I don't think we talked about it. When were you hired in this case?
Middle of last year. I am sorry, the exact date escapes me, but as the trial got pushed, it was beginning to middle of last year, and then I looked through it a little bit, and then it was continued. So really started my research towards the end of last year.
Okay, the
Got
end
it
of
into-
2025.
Yes, sir.
So 2 years after these men were indicted is when the state reached out to you.
As I said, they reached out at the beginning or middle of, I don't know when they were indicted, but if that's what you're saying.
But 2025 is the first time you were.
I believe so. I believe so.
Okay, and they were indicted in September of 23.
Okay.
correct? Okay. Let's get back to what you had. You were given video of the incident by the state, correct?
Yes, sir.
They gave you the medical examiner and autopsy reports.
Yes, sir.
Was that on the same flash drive?
It was.
Did they give you an interview, a recorded audio interview with Dr. Ross, the man that performed the autopsy?
I don't recall. I'm so sorry.
That's okay. They gave you Shelby County Sheriff's Office major incident packet, correct?
That came a little later.
Okay. And I think you told this jury that the only statement in it was from a man named Hal, and you don't even know who that is.
Correct.
There were no other written statements in that packet.
The rest of the packet is very similar handwriting, leading me to believe it was filled out by one person. As I thumbed through their policy, those major incident packets have to be filled out and then turned into their facility administrator or captain, whoever that is. So it seems like it was that one incident report, and then the rest of it was filled in just to get the packet turned in. That's just my assumption.
I'm gonna come back to that incident packet in a few minutes, but let's keep going on what materials you did receive. And then you got TBI interviews, according to your report, of the defendants.
It was either the TBI interviews or it was the interviews with the Shelby County Investigatives Division that I received.
That were in the TBI file.
Sure.
Okay. And you didn't get any, well, let me ask you this, how did you get those?
They were on that, they may have been on a separate flash drive, but they were on a flash drive as well.
And I think you told us that you had asked for all the statements, right?
The written incident reports.
If there was a written statement, you had asked for it.
Yes, sir.
Okay. Did Mr. Funk tell you that he had at least 25 other written statements from all of the officers that were in this incident in his file?
I don't recall. I don't believe so.
And he didn't send them to you?
I'm gonna object to the mischaracterization. He's talking about Garrity statements of other people.
I have never said the word Gary. I'm talking about written statements of the people on the scene.
I understand what you're saying. The state's welcome to redirect on Gary's statement.
Did the state tell you that they had at least 25 written statements from people that were in the jail that had given statements within a week of the incident about what they perceived, what they felt, what was going on? Did they tell you they had those statements?
That's not what I asked them for, so no, they didn't tell
Well,
me
you
that.
told us you asked for written statements.
I asked for written incident reports. You're
Okay.
saying statements. We're kind of getting to the same place a different way. I know
Okay.
you said we'll find common ground, and I'm trying to.
I do want to find common ground.
Yes, sir.
If they had written statements from all of the people in the jail that day, would that have been important to you?
It may have.
Would have been something that you would have liked to review?
Yes.
They did not send them to you.
Okay.
If there were written statements from all of the nurses in that file, is that something, the nurses that went up to the 5th floor, statements that described how the air was, how people were reacting, whether or not they were throwing up, whether or not they could breathe, would that be something that's important to you?
That would be less important. But if we're talking about let's have all the information, then yes, I would have reviewed them.
Use of force is based on what is reasonable under the circumstances, correct?
Yes.
And it's based on totality of the circumstances, correct?
Yes.
And it also is based on the individual officers of perception of what was going on at the time.
Correct.
And so if we had up to 30 statements describing all of that, that was in the district attorney's file, can we find common ground and agree that that would have been helpful in forming your opinions in this case?
It may not have changed them.
It may not have changed them, but it may have changed them. right?
Perhaps.
For instance, let's talk about your report. In paragraphs 6 through 8, you criticize the incident packet.
Yes, sir.
right? You criticize the fact that the officers involved had not submitted statements in the incident packet, right? Isn't that what paragraph 6 through 8 go to?
Written incident reports.
Right. If the highest ranking member on duty that day had told Mr. Funk's office that the reason there weren't incident packets was because they used something called Blue Team, which is a computer program, and they have to input their statements into Blue Team. But because of the death, they were immediately sent home, and they still haven't returned to this day. And so the highest ranking officer in the jail that day told Mr. Funk's office in a statement that the reason their statements weren't in the incident packet was because they were sent home and never came back. Would that not have affected your opinion?
I don't follow your question.
Well, can you fill out a statement in an incident packet if you're sent home and you don't ever again have access to the computer system?
No.
You can't
should
do it, can you?
You should fill, I'm sorry to interrupt. You
That's
should
okay.
fill out your report before you go home, whether it be on admin leave or the end of your shift.
And if they hadn't been allowed to by the Tennessee Bureau of Investigation, if they had been instructed to leave immediately, you would not fault them for it, would you?
Are we saying that TBI told them to leave immediately?
I have to pose this as a hypothetical. I want to ask you, if TBI had told them that, would that have affected your opinion?
On just
On
whether or
the
not
incident reporting
they wrote an
part.
incident
Yeah, paragraph
report?
6 through 8.
If TBI told you to do it, then I suppose you would listen.
Or if the Bureau of Professional Standards and Integrity had told them to go home immediately and not fill anything out. That would also affect your opinion.
My question would be why? I understand this is a hypothetical conversation, but why would that occur? What would be the goal?
I don't know.
Okay.
But the point is, if they had been ordered straight home and didn't have the opportunity to do this, would that have affected your opinions in paragraphs 6 through 8?
If I had written reports from them.
Right. And let's continue along this line. If, in lieu of getting on the computer and filling out Blue Team, I don't know why they call it Blue Team, but Blue Team on the computer, rather than inputting it on the computer, within 5 days, they drove down to the Bureau of Professional Standards and Integrity and had a union rep and gave a statement, and that statement was reduced to writing, and they signed it in lieu of doing the computer program, that would be something that's important to you, right?
Where in the policy or the standards that they're governed by does it allow them to do that?
First of all, I'm not allowed to answer questions. The
Okay.
judge would get on me.
I'm sorry. I apologize.
He's not under oath anyway, so.
I apologize.
I'm asking questions, and I'm not being mean to you, I promise.
I got you.
I can't answer that. But my question to you is, if they were sent home and didn't have access to the computer, and if they were told to come down and give statements in lieu, rather than doing the computer, and those statements were reduced to writing, and then they agreed to give those statements to the to the TBI as part of the investigative file to serve as their statement on the case, would that have changed, if all of that is true, would that have changed your opinion on this?
No.
You would still find fault with these two men for not, they would have had to disobey an order. They would have had to say, no, I'm not going home. Policy 806.07423 says I gotta fill out a computer. And so, no, Mr. TBIman, I'm not going home, I'm gonna do this.
I just don't see that happening. I don't see the TBI within 10 minutes of
Well,
Death
you
in
may not,
custody.
excuse me, finish your answer.
And within 10 minutes of a death in custody, sending people home. I don't know what the time frame was.
You don't see it happening. But if it did, if that is what happened, would you continue to fault these men?
If the TBI told me to leave the building right now, I would leave the building. So to answer your hypothetical question, no, I would not find fault with them.
And if the Bureau of Professional Standards and Integrity, I think that's basically internal affairs
Sure.
for the sheriff's office, if they told them to go home and not fill out reports, it's reasonable for them to do that, right?
I would first ask why you don't want me to write a report, but yes, to answer your question, I don't want to argue with you, it is reasonable to listen. I apologize.
Okay. It is reasonable for them to listen to their superiors and follow that order.
You just said something different, though. There's a difference between your superior and the TBI.
Okay. TBI or BOPSI, either one, they're ordered to go home and not fill out a report. Can we find some common ground and not quarrel and agree that that would be reasonable?
Can we also agree that officers are required to, I'm sorry, I'm not supposed to be
I
asking
can't
questions.
answer.
Nope,
your
nope,
question.
I'm sorry, you're right.
Okay,
You can make statements. but you
Nope,
can't ask
that was my fault.
okay.
I apologize.
We can agree with that, right?
Which part?
I'll move on.
All right.
I'm gonna move on from the paperwork, because we're not here about paperwork, are we?
No, sir.
We're here because these two men are charged with murder.
Correct.
You, we've looked at your CV, and it looks like you have a lot of use of force experience. Fair?
Yes, sir.
Okay. Before this case, have you ever served as an expert in a case?
No, sir, I was called as a character witness once for a death penalty case, but they elected not to let me testify.
So this is the very first case you have ever served as an expert witness, correct?
Yes, sir.
Okay. And you've never been qualified as an expert by a court, and that's okay, I'm not pointing fingers, but this is your first time to ever be qualified as an expert.
Yes, sir.
And this is your first time to ever draft an expert report, correct?
Yes, sir.
And I assume this is the first time you've given testimony in trial regarding use of force.
Yes, sir.
Okay. You understand, don't you, that Madam Court Reporter is taking down every word you say?
Yes, sir.
And your testimony today, it's kind of like getting a tattoo. Once you say it, you own it. I mean, it's there for life, right?
Yes, sir.
And you are the chair of the Use of Force Review Panel at the Davidson County Sheriff's Office, right?
Yes, sir.
Chair of the Use of Force. And you oversee, you review all use of force both in and out of custody, right?
The Davidson County is the oddball in the state where we do not do patrol inside of Nashville. So all of the uses of force that I review are inside of the jail.
Okay. I think your report said otherwise, but I'm not gonna fault you on that point.
I hope it didn't, but okay.
Well, let's see. Yeah, it says, I am the chair of the Use of Force Review Panel at the DCSO, overseeing the review of all uses of force, both in
Okay, so when
and
you,
outside of the jail.
when you say outside of the jail, we do serve civil warrants. We have armed security, the courthouse, for example, and armed inmate transportation. So that is what I meant by outside of the jail. Just nothing to do with patrol, arresting people, pulling people over.
So you were hired in this case. How did Mr. Funk come to find you? Do you work with Mr. Funk a lot?
No, sir.
Okay. Mr. Funk's the Davidson County District Attorney's Office, right?
Yes, sir.
When a supervisor, and you've touched on this, I think, and you've been a lieutenant, right?
Yes, sir.
In a situation like this, where there's been a struggle, a battle, inmates gotten loose, 4th floor, 5th floor. If during this a lieutenant gave an order, would you expect a line officer to follow it?
Yes, sir.
And an officer who refuses an order can be disciplined for it, right?
Yes.
And when your panel reviews use of force, you want to know whether a supervisor gave an order regarding that force, right?
Yes.
It's an important fact to have before you form an opinion about a line officer.
Yes.
I think you told Mr. Matthew you've heard the name Cleves.
Yes.
Do you know who that is?
From my understanding, is a lieutenant.
Did you talk to Lieutenant Cleves?
No.
Did she give you statements from Lieutenant Cleves?
No.
Did anything in your investigative file that was given to you by the state, is there one bit of information that they gave you to review that says Lieutenant Cleves ordered the leg irons?
I have heard of the name Cleves. Beyond that, I do not recall hearing any specific orders.
So you have never been shared information that Lieutenant Cleves ordered leg irons in this case?
No.
And I'm jumping ahead, we're gonna get back, but just while we're talking about it, if he had done so under the circumstances, that order's reasonable, right?
I think putting leg irons on a person who you just got done having that much of an altercation with is very reasonable.
Very reasonable.
Yeah.
Okay. Why don't, Ms. Fuchs, if you would, I wanna watch some video with you too, if that's okay.
Yes, sir.
Ms. Fuchs, could you pull up, and for the record, Your Honor, I am showing him what I believe is Exhibit 20, which was introduced during Dr. Lee's testimony. And the reason I'm showing you this particular exhibit rather than the one Ms. Hunter just showed you is because these timestamps, I believe we'll find, correspond with the timestamps in your report.
Okay.
Does that make it easier?
Yes, sir.
Okay. Why don't we start it? Let's just pause it here. On direct with Ms. Hunter, one of the things you said when she was walking you through this is you said, first question I have is why they aren't using the pie flaps, why they're rolling the doors, right?
Yes, sir.
If there had been a statement in Glenn Funk's file in which an officer explained why they were rolling the doors, would that have been important in answering that question?
Yes, sir.
Let's keep going. No, I'm good, thank you. While she's doing that, in preparing for your testimony, did you discuss with the state your issue with the pie flap? Did that come up preparing for your testimony today?
Yes, sir.
Did they tell you that there may be a statement addressing that very question you have?
Not that I recall.
Didn't even come up?
Not that I recall. No, sir.
Let's keep going. Let's pause it. One of the other things, you questioned today on direct why the not the man with the styrofoam, but the other man may have had his spray out. You remember that?
Yes, sir.
And you questioned that and thought it was unusual. Remember?
Yes.
Okay. If that man's name were Antonio Williams and he had given a statement in which he explained why his pepper spray was out, would that have been important in answering that question?
Yes.
Okay, let's keep going. Let's pause it. Pause it right there. Use of force is based on totality of the circumstances, true?
Yes.
And you describe proportionality as not necessarily being equal, but not so far off the reservation, so to speak, correct?
In both directions.
In
yes,
both
sir.
directions. And so when weighing the direction of the inmate's behavior, that factors into the proportionality, correct?
Yes.
And if there had been a statement that one of those jailers had been bitten so badly that she went to the hospital, that affects your examination of both totality of the circumstances and proportionality, doesn't it?
It could.
It could. And you weren't given that statement, were you?
I don't recall seeing a statement about being bitten, no.
Okay, let's go on. Pause it. You commented on them dragging an officer away. Do you remember that on your direct?
Yes, young lady with the reddish hair.
And in all fairness to you, you said, I don't know what's going on there. She could be injured. She could be emotional. She could be incapacitated. And I don't want to put words in your mouth, but that was the gist of it, right?
I believe I said incapacitated or emotional.
And you just don't know.
Correct.
And if there had been a statement in Mr. Funk's file that addressed what was going on with these people, would that have been helping? Would that have helped you form your opinions?
I would have answered that question.
Okay. Let's keep going. Okay, well, let's keep going. Actually, can you go back 10 seconds, Ms. Feeks? I'm sorry. All right. You see the spray? Now, we're about to see the throw you testified about on direct.
Yes, sir.
Stop. Do you even know who that man in the tie is?
No, sir.
on direct, you wondered, well, he has an opportunity to restrain him at that point because he's thrown him to the ground, and he missed an opportunity, right?
Yes, sir.
Okay. If he had come into this courtroom and told this jury that he couldn't see, he was completely out of a fight, he had to go down to the third floor and wash his eyes, that would have answered that question for you, right?
Yes.
And if that had been in a statement that was sitting in Mr. Funk's file, that question would have been answered before your testimony today, right?
It could have.
Let's keep going. And I just want to pause it here because we're talking about these statements. I want to make sure I understand your testimony correctly. You said you asked for incident reports,
Yes.
right? Did you tell Mr. Funk what you were looking for?
Written incident reports of anybody that was involved or that witnessed the incident.
Okay. So what you were really asking for is witness statements.
I was asking for written incident reports.
You're using the word incident reports, but when you're talking between human beings,
Right, and I'm sorry, I don't want to interrupt.
no, go ahead. I mean,
I'm using the words incident reports because that's what Shelby County uses in their policy, is the phrase incident reports, written incident reports.
so you asked only for the incident reports as written in the policy. You weren't talking about written statements of all of the witnesses.
Not necessarily. If I had the incident reports, the written that day, the written statements after the fact.
Wouldn't the response be, well, they're not in the incident reports, but we do have the statements?
Maybe.
Mr. Irvin, if you stand over that way, you won't be blocking the jury from the witness.
Of course. Okay. Let's keep going. All right, let's stop. Do you recognize Stevon Jones?
At glance, yes.
This man right here?
I'm sorry, I was still looking on the
Let me
screen.
put it on your screen.
No, it's okay.
Right there.
Yes,
He's got handcuffs in his hand,
yes, sir.
no pepper spray. Do you agree with me that he tried to approach Gershun Freeman, but couldn't get close to him to do anything?
No,
Let's back it up. Let's go back. There we go. All right, now, I think we gotta back it up more than that. Go 20 seconds. Here he comes. See how he just can't even get close to him and has to back away?
no, sir, I disagree.
Okay, tell me what you see there.
I see a person who made the choice to back away. I wouldn't say that he had to.
He made a choice.
Yes.
He answered the code blue down, he was downstairs in intake. right? And you had his statement, right, in the materials you reviewed?
That initial, with the Shelby County Office of Professional, I believe so, yes,
He
sir.
was downstairs when the code blue went off, right?
Correct,
And
yes.
this is the first time he's come to the floor.
Yes,
And so he's responded to the code blue because it's his public duty to.
to respond to emergency codes, yes,
Yeah,
sir.
he's got an obligation. And when he gets there, he can't do the job, right?
Can't do the job.
Okay. Do you think he just came upstairs and then all of a sudden decided, man, I don't want any part of this?
I think the video we saw right there showed an opportunity to put restraints on and choosing not to at that time.
He had the handcuffs in his hand, he tried to approach him, and he didn't
Been
get
asked
it.
and answered, Judge.
I'll move on. Okay. Let me ask you this. You don't think he did a good job there, right?
I think he could have done a better job.
Could have done a better job. But you don't see any excessive force there.
Correct.
You don't see any unlawful conduct there.
Correct.
You don't see any criminal activity there.
Correct.
Okay. Before we move on to the fifth floor, you had several criticisms of the fourth floor. In your report, paragraph 9F. 9F. You write, at no time did any staff appear to move into any controlling or clinching techniques. And then you put in parentheses, while the incident was on the fourth floor. And is it fair to say that you put that parenthetical in there because you did see controlling and clinching techniques used on the fifth floor?
Yes.
And with regards to your concerns on the, or your criticisms of the fourth floor, you say, instead of electing to utilize strikes, kicks, and additional chemical agent, at one point a staff member can be seen attempting to control inmate Freeman's ankles, but they are pushed away by another staff member. If staff had moved into a top mount or cross-body position, restraints could have been applied, leading to a better outcome.
Yes, sir.
What is a top mount position?
If a person is on the ground, face up or face down, and you have your legs straddling them, facing them, that would be considered a top mount.
Let me see if I can demonstrate. When you are, the person is down, either prone or supine,
Yes,
doesn't
sir.
matter. If they have one leg on one side and one leg on the other, that is a top mount position,
Yes, sir.
and that is what you wanted the fourth floor to do in your criticisms?
That's something that they could have done. That would have kept Mr. Freeman on the floor and allowed them to move to restrain him.
Did you see a top mount position on that video?
On the fifth floor?
Okay, and that was by Mr. Jones?
Yes, sir.
All right, we'll get there in a bit. But that's what you're saying. You're saying here, a top mount should have been used to control him, right?
It could have been used.
And top mount is good because you've got control of him. He can't continue to get away, but you're not putting weight on him, right?
People can escape from it, sure. You can control where the weight is, but you can have, it is a very advantageous position.
It's a good one
We'll
to
say.
be in.
Sure.
It's one that's trained.
Yes, sir.
Okay. Let's go ahead and move to the fifth floor. You told us you wouldn't try to engage him on the escalator, could be dangerous.
Yeah, it's just a huge fall risk for everybody involved. I understand that completely.
Now, let's pause it, right? Mr. Massey asked you about whether or not Gershun Freeman struck one of those officers. And I think your answer was that you weren't sure.
No, I said he appears to take a swing,
Okay.
I believe.
If there had been a statement in Mr. Funk's file from that officer describing the strike, describing how he responded, and describing the takedown, would that have been important to your analysis?
It could.
Okay.
May I add something?
Sure.
I don't necessarily have a problem with anything that happened in the past 15 seconds.
Okay, great.
We got a person secured to a wall. He swung. We threw a strike or two to give ourselves some space, clear some hands, and got the person on the floor and moved to control the body.
Okay. And I'm glad you said that. I think you kind of can feel where I'm going. We're going to kind of walk through this and talk about specifically what Stevan Jones did, because I really want to understand what you believe Stevan Jones did wrong.
Okay.
Does that sound fair?
Yes, sir.
All right. Let's keep going. All right, stop. Now, you have told us that you had a problem there with the hitting and kicking, right?
Yes, sir.
Okay. Before we talk about the use of force, one of the things you reviewed was the autopsy, right?
Yes, sir.
Okay. Today you have referred to that. I think you were talking about the fourth floor, so let me ask you before we move on. Do you consider what Stevan Jones was doing there stomping?
Yes.
Okay. You have reviewed the autopsy report, correct?
Yes.
Okay. And did you review the external examination?
From the medical examiner?
Yes.
Yes, sir. I
And
reviewed
did you review the diagram of the injuries?
Yes.
You would agree with me that Gershun Freeman didn't have a scratch on the back of his legs,
I don't recall.
not a contusion.
I'll give you this. I believe you.
Okay. You don't remember a hemorrhage.
No, nothing stood out. I
You don't
remember.
remember an avulsion.
I remember contusions on the head.
All right.
Uh, I do not recall seeing anything that stood out on the legs.
There was absolutely zero evidence of injury on the autopsy report to the legs.
Okay.
Okay. Now, I want to discuss fairness to these officers and fairness to you. You said you have to judge their actions under a reasonableness standard under the totality of the circumstances, correct?
Yes, sir.
And it's based on that officer's perception, correct?
The facts and circumstances that they knew or reasonably perceived at the time that they used force.
Knew or reasonably perceived.
Yes, sir.
Okay? And the evidence is there's pepper spray everywhere on this scene, right?
Okay.
There is evidence that officers can't see,
Okay.
that officers can't breathe,
Okay.
that their skin is burning, that their eyes are closed. This man has gotten up at least, he's been down and gotten back up at least 6 times.
Okay.
Maybe more, because the video is not that good, right?
Okay.
All right? So he's gotten up 6 times. In the materials you reviewed, were you made aware that the 5th floor houses dormitory style housing with open beds?
No, sir.
You never knew that.
No, sir.
Let's talk about another hypothetical. If it was dormitory style housing with open beds, and this man had made it to that dormitory style housing, that can potentially cause a riot, can it not?
A riot.
A riot, yes, sir, when you see an inmate on officer fight. when there is a brawl, when you've got an inmate running free, that can cause a riot situation. You've worked in the jail for 6 years.
I have. In my experience, that would cause an incredible amount of laughter out of the inmate
You
population.
think it'd just be fine?
I think the inmates would find it funny, not that I would find it funny.
Okay. Was it reasonable of these officers to try to end this now?
Yes.
This moment?
Yes.
Absolutely. Okay. And you've told us, when you were talking about the fourth floor, you want to get them on the floor and get them restrained.
Yes, sir.
Right? And one of the things you said is flatten their hips,
Yes, sir.
flatten their legs.
Yes, sir.
And you flatten their legs because you don't want them kicking you or hurting you, but you want to have them down so you can gain control of them.
Yes, sir.
Okay. And if Officer Jones is standing when this man is going down and there is active struggle, if he can't see, if he can't breathe well, you don't think it's reasonable, under the circumstances, to kick his legs and try to get him flat until they get this guy under control?
No.
That's not reasonable?
No.
What would you have done?
I'd have laid on him.
You would have just laid down on him, right?
On his
then.
legs.
He stops kicking him, doesn't he?
He's-
Let's back up 10 seconds. All right, let's watch it again. He stopped, didn't he? Why do you think he stopped kicking him?
Because somebody got his hips flat.
Because somebody got his hips flat. So he was kicking him to serve an objective, and when that objective was reached, he quit.
Okay.
Is that a fair statement?
In the confines of this 3-second vacuum, yes.
Okay. But that's what we're talking about, and we're gonna walk through it. But in the confines of this 3-second packet, which is where we are, he needed his hips flat. He needed his legs down. He kicked them until his hips were flat, and then he stopped. And you said that's reasonable.
It is.
It
It's
is.
reasonable that he stopped. What was your goal in kicking, in stomping on him, in kicking him?
To get
I'm
his
sorry, I'm
legs
asking a
flat.
question again, I'm so sorry.
To get his legs flat,
I'm so
right?
sorry.
Well, I gotta ask you a question, but it's to get his legs flat,
Yeah.
right?
That's not how you get somebody's legs flat.
In the fog of war, in the heat of battle, when you're blind and you can't breathe?
Yes.
Can I approach?
Yes.
Your Honor,
Yeah.
get one of your immediate arrest.
All right, let's take a recess, please.
Take your clipboards and your chair face down, please.
We're not gonna be too much longer today. I'll take a break and we'll be back with y'all in a few minutes. You may continue.
Yeah. Now I want to pick up where we left off. I think we're paused right now. They've got him on the ground, and Mr. Jones, who I'm interested in, is standing over it, correct?
Yes, sir.
All right. Why don't we play ahead? And I'll, Ms. Bukes, if you would, and then I'll tell you when to stop. It's going to be a few minutes, or a few seconds, really. All right. All right, pause it. Now, and that's at 5:35. What we just watched there, Mr. Jones is standing over him, and you would agree with me, the first job, now that he's down and in prone position, and you've testified, that's how most of these things wind up when you get him in cuffs, right?
Yes, sir.
His job is to get control of his hands and get him in handcuffs, correct?
Yes.
Okay, and we see him come down. That need to gain control of the hand, that's actually trained, right?
Yes, sir.
3 points of contact.
Yes.
And you don't have any problem with that?
No, sir.
Okay. And then I believe the video shows that that process took about 9 seconds.
Okay.
And here at 5:35,
If you need me to do that, I'd be happy to help.
I may ask you to. Here at 5:35, he has repositioned. He no longer has the knee in the back, correct?
Yes, sir.
Okay. And just so we're all clear, that knee in the back, perfectly reasonable.
It was fast. It was for a purpose. It accomplished a goal. And then when we were done, we moved it.
Great. We're on the same page. That was lawful.
Yes.
Okay. Let's keep playing. All right. Let's pause it there. And now we see Steven Jones in the mount position, correct?
Yes, sir.
And he is controlling him, yes?
Yes.
This is a position that is trained, correct?
Yes.
And he does not have weight on him.
There may be a little on the legs or on the butt, depending on how big either of them were. But
But
it's
no,
likely
no.
not a substantial amount.
Yeah, not a substantial amount, nothing unusual with this, right?
That's a good way to put it.
Nothing unusual. You don't have any problems at all with this position.
My only concern is that when somebody is handcuffed behind the back and you're going to mount them, that there's only about a 3 to 6 inch window that the hands can move. And if you put yourself in a position that would allow them to grab you, hurt you, pinch you, scrape you, whatever the case may be, that can be dangerous. So that has to be a concern for officers. It's no different than if I'm going to displace your head, not putting my forearm across the middle of your mouth, because that's a great way to get bit.
And I'm actually gonna pause you there because this is a good segue, so to speak. Your only complaint, it's not that it's unlawful or that it's not trained.
Right.
It can be dangerous for the officer.
Yes.
And the reason is, one of the known problems, so to speak, is that the inmate has his hands behind his back and the officer may be grabbed, right?
Yes.
That's known, right?
Yes.
And in your investigation of this case, did any materials you have indicate that Officer Jones was in fact grabbed?
I believe in the Office of Professional Accountability Bureau. I apologize for the acronym.
Sure.
I believe he references it in there. And he says that he threw a strike to get him to let him go.
You don't see the strike, do you?
You can, this other officer's in the way, you can see a hand to move. It's reasonable to assume that that's what it was.
Yeah, but you don't have a problem with that.
You've put yourself in a bad position. I don't love that. I'd rather you're in a better position, but nobody's ever going to be perfect.
Right.
So you have a duty to respond to that type of behavior. So yes, I don't necessarily have a problem.
Thank you for your candor. I appreciate it. Let's keep playing. You see him coughing there, don't you? Let's pause it.
Sure.
One, the spray makes you cough, right?
Yes, sir.
Okay. And one of the things, it's my understanding, and I know you've gone through the training, one of the things you're kind of taught is you tilt your head back because it runs down into your eyes and it keeps getting worse, right? And so one of the human responses is to kind of tilt.
Most definitely not.
No, what do?
You lean forward.
You just lean forward.
Yeah. Most
Okay.
people typically will lean forward, try to brush it off of their face. A leaning back response is not something that I'm familiar with.
Did you say you're trained to touch your face?
No, that's a pretty natural human reaction is to try to brush it off of your face.
Because you're not supposed to touch your face. So.
Most definitely not. You should
Most definitely not.
should use water first.
Yeah, so if you see your hands out like this, you just bending and grinning and bearing it, right?
Yeah, people will instinctually grab their eyes or sometimes, holding onto their forehead. People have different reactions to it,
Right.
of course. But you typically don't want to start touching your face because there's a fair decent chance you have some on your hands.
Okay. Let's go ahead and keep playing. All right, pause it. This is the first time we've seen Courtney Parham lay a hand on Gershun Freeman, correct? And it's not a hand, I say lay a hand, he puts a knee on it.
I believe so.
Okay, and that is done in response, you can't really tell from the video why that occurred, can you?
Right.
But it's done in response to something, correct?
I would agree.
And it's done in response to Gershun Freeman moving quickly,
Yeah.
and it's done in response to Stevon Jones flinching back quickly, right?
Sure.
Okay. Of course, you don't know because you haven't read any of the statements, right?
The Bureau of Professional was what I got from these two. But outside of that, you're
Okay.
correct.
The knee comes down, and I think you told Mr. Massey, the knee's trained.
It is.
And
It's something.
you don't, and again,
Sorry.
I'm not Courtney Parham's lawyer, so I'm not gonna spend a lot of time on Courtney Parham.
Okay.
Just kind of tell the story. You don't have a problem with the fact that he dropped the knee there.
Not initially. So how I would teach it, industry standard nowadays is knee on the upper back because that is a great way to pin somebody to a floor. There's no doubt about that, right? It also can be a very dangerous way to pin somebody to a floor. So how we train it nowadays is a knee on an upper back until they are restrained is acceptable. Once they are restrained, even just with handcuffs, that knee has to move either to the elbow pit, to the outer shoulder, to the butt, to the hamstring.
And again, I'm not gonna spend a lot of time on Mr. Parham, but you don't know how Mr. Parham was trained to do it.
The only understanding that I have, because Shelby County advertises it on their website, is that they employ PPCT, which is pressure point control tactics, which is just a version of defensive tactics programs that both police officers and correctional officers across the country utilize in many different agencies.
But again, you may have done it differently, and maybe you train it differently now, but you've told Mr. Massey you don't have a problem with that.
It's because it's something that came from their PPCT, and that they,
Okay, so that actually is in
Would allow him
PPC.
to finish his answer, please.
Okay, so,
putting the knee in the back, in between the shoulder blades, is something that comes directly from the PPCT training manual until they are restrained.
okay.
And then moving them into I'd have to pull the book out, but moving them into a standing position as soon as possible.
Okay. Let's keep playing. All right, pause it real quick. All right, so Stevon Jones was in the mount position, correct?
It appeared so.
And then we see this thing happen, okay?
Yep.
We've talked about the known risk of what can happen to an officer that's straddling somebody with their hands behind their back. He's now moved completely, right?
He appears to be in what would call an S mount, where you have one knee on the floor.
And that's an S mount, and he's got this leg on the other side.
Again, my feet are very healthy. If you'd rather I did that for you, I'd be happy to.
Okay, well, okay, sure.
So it
Just speak loudly because you're away from the microphone.
Yes, sir. It appears that he's in this position, working with him over here.
Okay, and that's trained. I mean, that's a legitimate position.
That's a great way in a jiu-jitsu competition to put somebody in an arm bar.
Okay. You don't have any problem with Stevon Jones being in that position right now?
No, sir.
Okay. Thank you. Let's go ahead and keep playing. Still no problem?
You're getting into a point now, you can see inmate Freeman's knees, or his feet, right? Like, it appears to be kind of behind Mr. Jones's butt. So it looks as though he's moved into what we call folding the legs.
Okay.
So you can either, two ways to do it, lacing the legs, a low lace, where
What's possible?
you cross the feet at the ankles and you bend the leg at the knee so the heels are close to the butt.
Okay.
Or,
Let's let him-
sorry, let me keep going. Or you fold one leg over behind the other knee pit, bend one leg up, and then you can really focus on that one leg. But both positions, you can apply leg irons in. Techniques can be utilized with leg irons on or without while they're in that position.
Great. That's what it looks like, and while he's doing that, I mean, that's serving a legitimate corrective measure, right? He is tasked with getting the leg in the leg irons, and it appears to you that at 7:25, that is what he's working on, right?
Yes, sir.
Okay, he's trying to get control of the legs, and what did you describe, how it looked like he was doing it?
It looks like a high lace where you take one. You imagine if somebody's laying prone, you lift one leg up, fold it over so their ankle's behind their other knee pit, and then you pick that second leg up, heel to butt, and then the feet are kind of in this position.
And that's what it looks like he's doing,
It does.
and that is trained,
Yes, sir.
and you are okay with that?
Yes, sir.
Okay, let's keep going. You're fine with what Stevon Jones is doing right now?
We're still waiting for leg irons.
Yeah.
Like, leg irons are not on right now.
Here we go. I'm sorry to interrupt you.
No, I was done.
Okay. That, did you see him just get it past leg iron?
Appears to be the leg irons coming.
Okay, and now, kind of walk us through what's going on here.
So he's going to apply them to one ankle at a time. It's essentially just a large handcuff with a long chain in between the two of them that go foot to foot.
Is that consistent with what you described earlier?
Yes, sir.
Okay. And then he's up. Pause it. Okay. Him putting on the leg irons, you have no problem with anything we just saw?
I don't love how long it took, but that doesn't make it inherently criminal or anything like that.
Thank you. It took a little longer. Because they don't carry leg irons on them, right?
Right, that's not standard to carry leg irons on you inside of a
Okay.
jail or heavy.
So you don't love how long it took, but you don't have a problem with anything Steven Jones did waiting. And, let me stop there. You don't have a problem with what he did waiting?
No,
Okay. And then he put the leg irons, and you didn't have a problem with that?
no,
And then he got up, correct?
yes.
Okay. And that is the last time Steven Jones ever laid a hand on Gershun Freeman.
And in my opinion, it shouldn't have been.
I didn't hear you.
In my opinion, it shouldn't have been.
It shouldn't have been the last time he laid a hand on him.
Because when we talked about earlier, is that you have to be able to ramp up and you also have to be able to ramp down. And part of the reason we train people in CPR and first aid and de-escalation and mental health first aid and all the other things that we put correctional officers through to give them the tools to do this job is so that someday you can make that transition from being an officer in the midst of a fight to being a caretaker.
Okay. You understand, Mr. Miller, that Mr. Jones is not charged with neglect or failure to render aid. He's charged with murder.
Correct.
Okay? So failure to render aid isn't a question,
Okay.
right? All right. But,
If y'all put the bench for a second.
talk about this. Your last statement was that it shouldn't have been the last time he touched it, right?
Correct.
Okay. The policy is that you observe the inmate, right? You keep an eye on him to see how he's doing.
Yes?
And of course, you don't have any of the statements from the people that were actually observing him to know what kind of condition he was in, do you?
Correct.
You don't have that because Mr. Funk didn't give it to you, correct?
Because I don't know. I'm just
don't have
answering
it.
that I don't have them.
Okay. Again, reasonableness under the circumstances, totality of the circumstances. If Steven Jones were blind and coughing and needed to gather himself, once he got those leg irons on, he gets up. You don't have a problem with anything that's happened down there. And did your investigation, the materials you got, did you know that this 5th floor right off view of the camera, and Judge, I'm not arguing facts that aren't in evidence because Exhibit 1 shows it, that right off, if the camera's pointed the other way, it leads outside to a gym. Are you aware of that?
No.
Did you watch all angles of the video or only the video that Mr. Funk made for you?
I watched this video.
You have not seen any other videos in this case?
No.
You have not seen any other angles of this video?
The angles of this video are the ones that I have reviewed.
This is literally the only thing they gave you?
Yes, sir.
Okay. If it showed Mr. Jones walking to the double doors to the outside, trying to gather himself, trying to gain his composure, that's reasonable under the circumstances, is it not?
After you put somebody in the recovery position, absolutely.
There are 4 officers, let's keep playing. Pause it. We have 4 officers that are observing and have custody and control of Gershun Freeman. When you work in a correctional institute, you work on a team, right?
Yes, sir.
And you rely on your team, right?
Yes, sir.
You can't do it all yourself.
Correct.
And a lot of these guidelines are implemented by a number of people,
Yes.
right? And if he gets up to gather himself and walk and try to get some fresh air after being the one to finally get leg irons on him, and he knows that 3 or 4 other officers are watching this man, are you telling us that that's unreasonable?
Yes.
That's unreasonable.
I'm telling you that as a part of that team, as the person who finally did it correctly, who finally got him down, got leg irons on him, got control of the body, that you now have to make the transition from being a correctional officer to a caretaker before you move on and do anything else. And I know that because I have done it many times in my career.
Even if you've got the lieutenant and 3 other people standing over Gershun Freeman, and you can't see.
You just said yourself he was part of a team.
Well, let me ask you this, okay? Let's talk about emergency care.
Okay.
You've had CPR, let's look at your CPR. You've had some training on this, right?
CPR and first aid
Okay.
as an
And-
instructor.
And first aid, I was supposed to take CPR and first aid for scout trip. I skipped the CPR, but I did take the first aid. The first thing you do, it's about securing the scene.
It is.
Before you do anything.
Correct.
Okay, and part of securing the scene is it safe for me?
Correct.
Is it safe for me? Am I in a safe position and am I capable of rendering aid?
Okay. Yes.
And if Stevon Jones didn't think that the scene was safe for him, and again, we're judging this in real time,
Yeah.
with his perceptions. If he didn't think the scene was safe, meaning he could safely perform whatever life-saving you say he should have done, if that's his perception, is it reasonable for him to walk away because the scene isn't safe for him?
You still have a responsibility to keep the inmates safe. So what is your purpose in walking away? What is your goal? I'm sorry to ask a question. I'm so sorry.
The scene is not safe for Stevon Jones because he can't perform his duties. He's got to go.
Objection, Your Honor.
Yep, you need to
can
ask a question, sir.
If he felt like he couldn't help, he did his duty, and now he's got to go get right. Is it your testimony to this jury that that is unreasonable? If that's your opinion, we'll move on.
I believe that as a part of this team and the person that finally applied the leg irons on, that he should have been part of the group or people that moved him into a recovery, a seated, a standing position. Yes.
I want to summarize, if we can go to the clips. What I've done, Mr. Miller, is I want the jury to get this, so I want to introduce it through you. I've made some clips of this, okay? It's the things we've talked about. The first encounter, the knee in the back, the straddle, the leg irons. I want to summarize your opinions regarding those things, okay?
Okay.
And I think that'll be it for me.
Is this a video we've made like right now?
It's this video.
Oh.
Okay, this is to help the jury and to summarize.
We're recapping.
We're recapping.
I understand.
All right, if you could play the first video. This is the only time we see Stevon Jones on the 4th floor. Okay. You think he could have done more, but there's nothing unlawful or excessive in that clip, correct?
Correct.
That's all Stevon Jones did on the 4th floor.
Yes.
Okay. Let's play the second clip. There we see the takedown, right?
Correct.
And you've testified you want the hips flat, you've testified you want the legs flat, because the goal is to get him under control.
Yes, sir.
You do have a problem with the kicking,
With the stomping.
with stomping in your words. But we know, because the autopsy's in evidence, that there's not a scratch on his legs back there.
Okay.
Okay? But to be fair to you, to summarize you correctly, you have a problem with that kicking.
Stomping.
Stop. Let's play the next game. And, well, real quick, let's pause. When Ms. Hunters asked you about all of these policies and procedures related to prone position and asphyxiation and all of that, stomping's not related to any of that.
No.
You're not suggesting that stomping had anything to do with this man's demise.
No, but it's just poor technique. Yeah.
Just poor technique. And that's really what it was, poor technique.
Yes, sir.
Okay.
As far as the stomping goes, yes.
Let's keep going. Or, could you start that over again, Ms. Hughes? All right. That's the knee in the back, trying to get control of the hands. Does get control of the hands. Gets off. And you have no problem with the knee in the back for that short amount of time.
Nope.
That's how they train it.
Yes.
That was good technique.
That was a good application.
Okay, great. Let's play the next video. This is the straddle. And I've only done 30 seconds of it for the summary. You have no problem with the straddle. You call it a top mount.
Yeah.
Actually, that's a different clip. That's when he moves into the S mount.
Yep.
According to Parham gets on it. But you didn't have a problem with any of that either, did you?
With the straddle?
Yeah.
No, we're weight off of the back. We're knee on the leg, or we're butt kind of back on the butt and the hamstrings, keeping the legs still.
All right.
Don't necessarily have a problem with that.
All right. Let's play that. Or we just played that one, didn't we? Let's play the next one. That's the strap.
Yeah.
That's just the top mount. You have no problem. He's down on the legs.
Correct.
Okay. And that position waiting on leg irons is kind of textbook, right?
It can be. I'd much rather have the legs laced up and not be sitting on them myself, particularly if you were nude.
Because you may get cracked.
Yeah, you put yourself in as much of an advantageous position as possible.
Right. All right, let's play the next clip, if there is another one. Oh, yeah. And here we have the leg irons. Lieutenant Cleaves has passed them to him. He's gathering the legs. And he's off. And you have absolutely no problem with that,
With placing the leg irons on, no.
right? And as soon as he's placed the leg irons,
You win.
he's won and he walked away.
Yes,
Okay, and you have no problem with that?
I do, as I've said.
You have a problem with him going to gather himself, and I'm gonna ask you that. So, to summarize your testimony, you have a problem with the kicking right at the moment of control, stomping. You have a problem with the stomping at the moment of control.
Yes,
And you have a problem with the fact that he walked away to try to catch his breath rather than staying with him and providing medical care.
I think he should have, with the other officers that were there, put him in the recovery position. And then, when you need to go catch your breath, you go do so. You do not leave somebody prone like that if you're going to walk away.
When he walks away, there are 3 other officers there, and there's still.
Been asked and answered.
No, but there's a different question. That's a predicate.
I'll let you ask this question.
There are 3 or 4 other officers there, and for some reason, they don't move him yet, right? And you even see another officer come, and they actually pick his legs up. Why would you, somebody in leg irons, why would you pick their legs up?
I wouldn't,
You would never do that?
no, not by the chain.
And if someone had done that, as you're evaluating this use of force, would you want to know why they did that?
Perhaps.
Would you want to know what they perceived at the time and perceived regarding Gershun Freeman?
Yes,
If that had been a statement in Mr. Funk's file, would that have assisted you in your analysis?
could have.
So we've got the stomping, and we've got the walking away to gather yourself. Those are your 2 complaints of Steven Jones.
That he was not a part of a group that, once they gained control, did not move him into the recovery position.
That's all I have. Well, let me check with counsel. That may be all I have. Thank you, Mr. Miller.
Thank you.
Does they have any questions? Regret?
Yes, Your Honor.
All right.
When you testified about conceding that there may have been a testicle grab, that comes from a statement that you reviewed, is that right?
Yes,
Okay, and that statement, when that statement was taken, that was taken by somebody who also works in the sheriff's office, is that right?
yes,
Okay, and there wasn't anybody asking any tough questions during that interview, right?
no,
Okay, it was very, it wasn't like a cross-examination like you just went through.
She's leading. I think she's forgetting she's under arrest.
You can ask him, was it a cross-examination?
Yes, Your Honor, I apologize.
No, that's fine.
Was it a cross-examination like you just went through?
no,
And when you listened to that, well, let me ask it this way. Did you see a testicle grab?
it's difficult to see.
Did you see it?
I did not see it.
Did you take his word for it?
I did,
And he wasn't basically cross-examined or pushed on that
correct,
when he gave that statement?
correct.
Okay. Do you like to see the best in people?
I do,
Okay. So when he made that statement, did you believe it?
I did.
I want to ask you about getting the leg irons. You testified that you were fine with the fact that they wanted to use leg irons.
Correct.
You also testified earlier that you felt like Courtney Parham was staying on the back for too long.
Judge, we are still leaving like she's cross-examined.
This is a predicate to the question, Your Honor.
All right, I'll let you ask the predicate, but then you let the witness answer rather than suggesting the answer.
You testified earlier that during that leg iron period of time, you felt like Courtney Parham was staying on the back for too long.
Yes.
Okay. Are you a lawyer?
I am not.
Have you been instructed on the law in this case?
I have not.
Have you read the jury instructions?
I have not.
Are you familiar with the theory of criminal responsibility?
A bit.
Let me ask you this. During that same period of time, while the leg irons were being retrieved and Mr. Jones was on the back of Mr. Freeman and Mr. Parham was on his back with his knee for that long period of time. In your opinion as a use of force expert, was it easier or harder for Mr. Parham to stay in that position on Mr. Freeman's back in violation of use of force policy, or easier? In other words, did what Mr. Jones did make it easier or harder for Mr. Parham to violate use of force?
Did what Mr. Jones do make it easier or harder for Mr. Parham to violate use of force?
That is rank speculation, Judge.
Well, if he knows, he can answer. If he does not know and he's guessing, he'll have to say he doesn't know.
I would say it would be speculation at best for me to answer that.
Okay. Have you ever heard of a two-man team?
Yes.
You used the word team earlier.
Yes.
One person's at the front, one person's at the back.
Correct.
In this situation, who's at the front and who's at the back?
Parham's at the front, Jones is at the back.
Why does somebody sit in a mounted position?
It's a great spot to just hold somebody still while you gather yourself, catch your breath, look for your next opportunity.
So he's in the process of holding somebody still, is that right?
It appeared
Is
so.
that what you just said?
Yes.
And while he's holding that person still, Mr. Parham is on the back with his knee applying pressure, appearing to apply pressure. Is that right?
Correct.
So does it make it easier or harder for Mr. Parham in this situation, the fact that Mr. Jones is on the back holding him still?
Does it I'm sorry, I misunderstood your question the first time. Having two people there will make it easier to hold somebody still when you are both on top of the person, either at the front or the back.
And is your opinion any different than when you testified in direct examination, that in your opinion, Mr. Parham being on the back in the position that he's in, that we see him on the screen at that time, for the period of time that he was, while waiting for the leg irons, has your opinion changed that that was an improper use of force?
No.
When you testified that you were fine with getting the leg irons, were you necessarily fine with Mr. Parham staying on his back the way that he was the entire time that it took to retrieve the leg irons and get them there?
If he were still a legitimate threat,
Was he though?
it doesn't appear to be. But giving officers that latitude to make tense, uncertain, rapidly evolving decisions in those situations, we give people that type of small latitude in those situations. I would find anybody in this courtroom hard pressed if I cuffed your hands behind your back and laid you on your face to have you stand up and run away from me without the use of your hands to do so. I doubt any of us could do it. I certainly can't. So there's very little, if no threat, and you have to start ramping that down. Once you have the leg irons on, it is very, very negligible what the threat could continue to be.
to show what it would be like to put somebody in a recovery position, just yourself.
I did.
Do you think that it would be easier for you to show the jury the correct way to put somebody into a recovery position if you had a volunteer?
Absolutely.
Okay, we have a volunteer.
I'm sorry, Your Honor. I was hoping it was you.
Your Honor, may we have a
I'm too old.
volunteer?
I'm too old to go on.
Hardly. Hardly.
First to come around.
Feel the weight down on your stomach.
I could probably do that. That's about all.
Put your hands behind your back and clasp.
Judge, can we stand?
Yes, sir. You, please stand up, so you can sit.
So what you have here, he'll hold on to his hands and his wrists as tight as he can. So if I'm trying to keep this person down because I just got done fighting with them, I'm tired, I'm catching my breath, I finally got them cuffed, and I need to hold them down. What we used to do all the time was either front or rear leg, that knee in the spine, or that knee in the upper back, right? Now, you tell me stop when it starts to hurt. So, I'm pretty big, but you can put a lot of pressure on there to the point of causing pain, to the point it causes it difficult to breathe. So, when we teach it nowadays, we teach a knee in the butt, and we're gonna get intimate with each other here. You teach a knee in the hamstring, or if I really need to hold this person still, just roll with me a little bit so this doesn't kill you. I'll put my knee on the inside of the elbow pit, and I'll hold them still here. As those handcuffs are on, I can just gently start separating the hands, and it causes a little pain. When I realize we're on, our leg irons are on, I don't need to keep this person in this position anymore, right? I can put my hand underneath the head, I'll take my forearm and I'll underhook that far elbow, and I'll roll them up into this position. This is recovery, this is weight off of the chest, this is I'm nice and stable and balanced, this is I can support the head, I can really still control this person if I get this in deeper and hold them up tight. Or if he decides from this position, he's gonna go back acting crazy again. He wants to spit, bite, headbutt, thrash about, whatever the case may be. I'll take that knee, as you guys on the backside of the jury can see, and I'll pin that forearm to the floor, and then I'll just gently separate the hands. It hurts very, very badly. From this position, exactly the reason we do it, I just go the direction that my fingers are pointed. And then I can sit him back up. I can sit him back against me, open up his airway, give him a sternum rub. I'm not touching anything intimate or strange. And eventually, even if I'm by myself, I'll say, hey, bend that right leg for me, bend it in. I'm gonna roll you up onto the leg, ready, 1, 2, 3. And then I'm gonna help you up to your feet, 1, 2, 3, legs underneath. And we escort away.
Thank you.
Yes, ma'am.
I have another question.
Mr. Massey?
Before Mr. Massey goes, Judge, I wanted to move that into evidence, and I forgot to. If I could move.
Move what it is.
So it's a thumb drive with the video I just showed.
All right.
Mr. Miller, and then it has the clips that we just showed.
That will be exhibit 26. I'm sorry, 27.
27.
Do you have a little envelope to put it in? Oh. Go for it.
Mr. Massey.
Mr. Miller. I want to isolate the point that is our confusion with Mr. Palmer, okay?
Okay.
On fourth floor, you don't have any problem with anything he did there.
Not that I recall, no, sir.
On fifth floor, he didn't get there till the man was already down, right?
Correct.
And he came around, and I believe that's the point Mr. Jones is on the back of his leg, and Mr. Farr kneeled down for a knee.
Correct.
Okay. Now, at that point, that's within policy, right?
While they're trying to get restraints on, to include the leg irons,
Okay.
it appears to be.
Okay.
As long as they're being extremely cautious, as their policy says.
Right. And while he's got the knee in him, on his back, is that you're not saying that's being for punishment for you,
No, sir.
being for restraint,
It appears to be.
but there was a better way, you believe?
Yes, sir.
And that's something that you would have in the book, that you learned from.
That is something, you say the book. You just
Yeah,
mean,
book. Did you talk from a book, or did you go on the computer, or get the information from somewhere?
my curriculum that I teach is a blended curriculum from thousands of years of martial arts that we have applied into a correctional and law enforcement setting.
You have used yourself, I believe you said, the knee in the back,
I have,
many times.
too many times.
To me, it's an effective way to have control over someone
It is.
and to secure someone.
It is.
It can be against policy if you're putting all that weight on that knee and keep it there too long.
If you're not being extremely cautious and you're not monitoring the person, yes.
And we talked about Mr. Parham watching.
It appears that his face was looking down, yes.
Watching Mr. Freeman.
Yes.
And we agreed that there's no way for you to tell how much weight is being placed on his back.
Correct.
So tell me then exactly, what is the point where you say that Mr. Parham went over the line and breached policy?
What is the point that he went over the line and breached policy?
Yes.
Once he no longer saw or felt an imminent threat from Mr. Freeman.
Okay. And when did that occur?
That's not one of those things that you can quantify with time. It occurs somewhere in that altercation before Mr. Parham gets up,
And you know that because why?
based on many years of experience.
Once the leg irons took off, and Mr. Parham was still down on Mr. Freeman.
Okay.
He was alive.
You're saying once the leg irons were on him.
And once he had his knee down on him.
Okay.
Okay.
I just want to make sure we're talking about the same spot. That was all.
Good. Slate now.
I get you. I understand.
And the leg irons were gonna be placed on Mr. Freeman.
Yes, sir.
You're okay, as long as he's distributing that weight and watching, you're okay with Mr. Parham being on Mr. Freeman's back.
I'd rather he put it in one of those other positions that I showed, but that doesn't make it entirely wrong.
Thank you.
Yes, sir.
And then, I think it's the lieutenant comes back with the leg irons.
Okay.
Someone comes back with the leg irons, and Mr. Jones puts them on.
Okay.
Is that right?
Yes, sir.
And he's still okay at that point. as far as not going over the line.
Is he? Maybe,
Yeah.
maybe not.
And maybe or maybe not is okay when you're looking at policy,
Sure.
but this is a marketron.
I agree. Which if we were judging this use of force based on a gentleman that didn't die, I would say that we could have that argument all day long and be willy-nilly about it. But because we're talking about a dead body, a dead human being, that maybe or that when becomes exponentially more important. I can't tell you exactly when that imminent threat subsided, but I can tell you, based on my research and my years of experience in both dealing with, reviewing, and teaching use of force, that imminent threat subsided sometime before Mr. Parham and Mr. Jones got off of him.
But still, if his training, if Courtney Farms' training is to stay on him until clothes arrives because of Priya,
See, now you're changing the scenario entirely. Now we're talking about Priya.
well, that's part of why he stayed, right?
Is it? I'm sorry, I'm not supposed to be asking questions. I keep doing that.
Do you know? Is that part of why he stayed?
If it is, it's incorrect.
Why did they bring him a smock?
Human decency?
Covered with? Yeah. Why did they bring him something to be covered with?
Human decency.
Human
Decency.
decency.
Decency. They were trying to be kind.
See that we're just being nice?
Yes. That's what I would have done.
Nothing to do with prayer.
No. Priya does not apply in that situation.
What does Priya say?
The Prison Rape Elimination Act of 2003 says that for something to be a Priya violation, it has to be unwanted, repeated, sexual in nature, and for some form of sexual gratification.
So if they didn't want to carry him nude through the jail, naked through the jail.
I don't recall them carrying him on any videos. But, I'm sorry, to answer your question,
What,
I think it's reasonable to not want to carry a naked man throughout the jail and to want to put a sheet on him. That has nothing to do with Priya. That has everything to do with being a decent person and covering up a naked person.
and if Mr. Pong stayed down on Mr. Freeman, while waiting for that sheet to cover to be decent, and he was secure, he wasn't going anywhere, and he wasn't putting pressure on him. There's nothing wrong with that, is there?
So their policy specifically talks about leaving somebody in the prone position while they are restrained.
He's flat. He's flat on the ground. Nobody's putting, I mean, if he's not putting weight on him, there's no problem with his breathing.
If I may.
Yes.
Inmates, so this is page 16, Shelby County Sheriff's Office Use of Force Policy, letter N. Inmates may not be placed face down in a prone position while in restraints because of the possibility that they may be unable to breathe properly and asphyxiate. It does not say that they may not be placed and placed weight upon. It says they may not be placed, right? If an inmate must be placed face down in a prone position, he must be observed continuously by security staff, must exercise great caution when placing their body weight on an inmate in the face down position, ensure the inmate is able to breathe effectively. Once staff has gained control and the inmate is compliant, this position must be changed as soon as possible.
As soon as possible. And if his training was to stay there until his lieutenant told him to leave, or until the smock arrived, then that's what he should do.
Then his training was poor at best.
I mean, he's just following orders, right? And
Well, I'm sorry, he hasn't answered the question yet.
I said he was just following orders.
Who-
Just speculation.
Yep, he was told to stay there until the smock arrived and until he was relieved. Then, he was following orders.
You are to follow lawful, reasonable orders, and a reasonable person.
You were told by
Finish
his,
his answer, Judge.
it's being qualified.
Well, if you just let it, once he stops, take a breath, and then you can ask another question. Yes.
I'm finished, sir.
So if, you would agree with me, wouldn't you, that Mr. Freeman, during the course of that evening, the course of the time from when he burst out of his cell, that, people were put in danger? He was put in danger,
Yes.
and the people around him were put in danger. They got sprayed and all kinds of things.
Yes.
Did?
I don't know about biting, but yes, people were put in danger.
And when you look at the overriding policy of the sheriff's department in making its policy statements, the overriding policy is that when an officer is having a confrontation with a inmate, that the officer's safety is paramount.
Yes, sir.
And so, where are we now? If you could get me as close, get me and the jury as close as you can in time to where Mr. Parham went over the line, in your opinion, to violating policy. Not a better practice. I'm not talking about that. I'm talking about in violation of policy.
It's not something I can give you an exact time on, sir. That is something that you have to judge based on review of all the evidence and determine in that moment would another reasonable person, given similar circumstances, have felt an imminent threat from Mr. Freeman while he was in that position.
And that would tell you whether they were in violation of policy.
That would tell you whether or not they were acting objectively reasonable, which Shelby County's policy does not allow for officers to act objectively unreasonably. So yes, that would be the time they violated policy.
And you would agree with me, I'm gonna wind it up here, I hope, that the Shelby County policy also, in section N that we looked at, said that as long as being watched, and as long as they bear too much weight on the back, when you got the knee in the back, that procedure is okay.
As long as they move him as soon as possible, once it's safe to do so.
Yeah. And removing that, let me ask you this, if this is done correctly, if this move is done correctly, putting the knee in the back, then you're not putting too much pressure if it's done correctly, right?
Okay?
Do you agree with that?
Yes, sir.
Okay. Then there's no harm done if he's just keeping him down with his knee until he's told.
You keep using that phrase until he's told to leave, or until he's told to do so. Officers are expected to make split-second decisions in situations like this, and if every single situation inside of the jail was waiting for my supervisor to tell me what to do, that would be troubling.
Yeah. Real time is very, very different than,
Very different,
yeah,
right?
than what's in the policy manual, isn't it?
It's just a fast-paced environment. Oh, I didn't say anything.
You said you had used the knee in the back many times in the past.
I have.
Were any of those times, did they involve people that had severe coronary or osteoporosis, whatever that disease, that vascular disease that Mr. Freeman had? What? Did any of those people have that disease?
I have quite literally no idea. Yes, sir.
Sure, any other questions?
I have no follow-up, Judge.
Dave, anything else?
Yes, Your Honor.
All right.
It's brief though, I promise.
The Lawyers always say, "I'll be brief." That's okay. I've heard that from all three sides.
Once Mr. Freeman was prone and in handcuffs, who could he hurt?
Nobody.
Okay. And once he was prone, in handcuffs, and in leg irons, who could he hurt?
Nobody.
Kept my promise, Judge.
Thank you. Ms. Massey, anything else?
One question. Are you saying that this man died of asphyxia?
I'm no judge, Your Honor. He does not have that qualification.
He's not an expert, cannot give that opinion, he's not allowed.
He's not saying that.
No, he's not allowed to say what he thinks because of it. Because he's not an expert in forensic pathology.
When making your opinion, did you know that Dr. Marco Ross did not find mechanical asphyxia?
I read Dr. Ross's report, yes.
All right, in your opinion?
Yes.
Mr. Irvin?
No, sir.
Anything else from the state? Even brief? All right, thank you. Thank you, sir. You can sit down.
Yes, sir.
Okay. Ladies and gentlemen, we are, it's about 6:05. We're moving on with this trial. I think, last Friday or maybe Monday, I told y'all, I was thinking maybe we'd be through Thursday or Friday. Well, tomorrow is Thursday. I think the state has one final witness in the morning. Then we'll let the defense decide whether or not they want to put on proof. We're doing the best we can. I hope we're taking good care of y'all. We could go through Saturday. I don't know. I can't promise you anything because I know what the proof is. But we're working as fast as we can. And we understand that you guys aren't with your families, and we appreciate your service. Okay? So with that, we're going to stop and let y'all go and be back in the morning at 10 o'clock. So leave your clipboards.